Prayer for next, my lord. Due
कोई
to
एडवांस
Mr.
नोटिस दी?
Due to argument council Mr. Rajiv Sharma, my lord.
What do you mean due to?
Not bail.
कल आए थे, कल ही डिसमिस कर देना था।
Lordship.
कल कहाँ थे? Where were you yesterday? ऐसे नहीं होता, right? Not acceptable.
Next Tuesday, Wednesday, ready के my lord.
देखिए इतना पुराना केस पढ़ने में टाइम लगता है, आपने एडवांस नोटिस क्यों नहीं दिया? कंप्यूटर भी बीमार हो गया था क्या? फोन खराब हो गया था आपका? You can't do this. I will not permit this. एडवांस नोटिस आप नहीं भेजते हैं, आपको मना किए हैं क्या? फिर एक दिन पहले एडवांस नोटिस भेजना चाहिए ना। कल आप नहीं आए, आपका मैटर आज आ गया, लिस्ट में था, क्यों नहीं आप एडवांस नोटिस भेजे? ऐसे हम अटेंड करेंगे नहीं। इम्प्यून ऑर्डर पढ़े, फाइल निकालिए और पढ़ना शुरू करिए, फैक्ट प्लेस कर दीजिए, लॉ के लिए उनको सुनेंगे। यू स्टार्ट योर आर्ग्यूमेंट। इम्प्यून जजमेंट्स को प्लेस करिए, क्या सब्सटैंशियल क्वेश्चन ऑफ लॉ को प्लेस करिए। हु इज फॉर द अदर साइड? कौन? वो भी नहीं है, उनकी तरफ से कोई प्रेयर फॉर एडजर्नमेंट नहीं है। चलिए पढ़िए, सब्सटैंशियल क्वेश्चन ऑफ लॉ क्या है? फाइल कहाँ है आपका? कब बना था सब्सटैंशियल क्वेश्चन ऑफ लॉ?
2003
तो आपके पास नहीं लिखा हुआ? आज तो मैं ऐसे टाइम नहीं लेंगे। कितना दिन हो गया आपको प्रैक्टिस का?
2 years.
2 years हो गया ना?
सेकंड हाफ में स्टार्ट किया जाएगा।
हाँ ठीक। सेकंड हाफ में तो हम फर्स्ट अपील का डिक्टेशन देंगे, उसके बाद टिक करेंगे। चलिए
Item 2, second Q 391 of 2003.
I have prepared one short notes. Judgment of the owner for performance of contract, and I was the plaintiff, so was decreed in my favor, and thereafter I was the verdict. If you also will see, two things is important in this case. First, the suit plot is 1.5 kattha, out of which 3 claimants are there. The 3 successors are there: Hira Singh, Dasarath Singh, and Anand Singh. I have purchased half of kattha from Hira Singh and Dasarath Singh, and agreement from Anand Singh or Jharkhand Singh. And this is the only dispute, because after agreement, he executed sale deed to another person.
agreement with Anand Singh.
Anand, I had an agreement with Anand Singh to Jharkhand Singh. And after filing of the suit for a specific performance, they have sold it.
When did you file? What is the date of agreement?
Date of agreement is 30/96.
Which is that exhibit?
3397, Exhibit 1.
33, record 97,
97.
Exhibit 1. Okay. Was there any timeline?
Timeline was granted 1998, time granted to till registration. Prior to that, when I came to know that he is planning to sell other person, prior to that I have filed the suit. And after institution of the sale suit on 24/9/97, he sold 136 square feet to dependent second party and 170 square feet on 27/9/97 to dependent third party. So suit was decreed by specifically stating that
Yes.
that the agreement has been sufficiently proved through oral evidence of PW2 typist, PW3 who was the witness to the agreement, PW15 and 17 who out of which one PW15 was the 16, 15, 17 and 16 also. 16 was the advocate who has drafted the agreement, and also the signature of Jattu Singh alias Anand Singh was verified through Wakalatnama executed on the same day by Jattu Singh in another 107 proceeding, and that was compared and it was found that the signature is genuine. Besides that,
So for the proving the agreement, who were the relevant witnesses according to you? PW, PW 16,
PW2, PW3,
2,
PW15 and 17 has proved the
15
agreement.
and 17.
Hmm.
Where is the plaintiff amongst these?
Plaintiff,
Is PW2?
I am PW19.
So you must have also supported your
I
case.
have also supported. And one thing is DW2, who is the son of Anand Singh, who has also supported the factum of signature and evidence. DW2.
Plaintiff is PW 19 and PW2, son of Anand Singh.
DW2 सलाम का.
DW2.
हाँ. DW2 तो टाइपिस्ट था, वो मेरा विटनेस था, उनका विटनेस.
DW2 as son of Anand Singh.
Who has also supported, who has also said that the signature of it.
Also identified the signature.
So the agreement has been completely.
Just a moment. Signature of Anand Singh. What was the Wakalatnama of 107 proceedings was exhibit?
107 proceedings.
Exhibit number
6. And that was compared on the request of the defendant itself. That I will come here.
Just a moment. The learned counsel for the appellant has admitted that this appeal arises out of suit seeking specific performance of agreement with regard to sale of immovable property dated 13/3/1997 within bracket exhibit 1. The trial court had decreed the suit and the first appellate court has reversed the judgment, and therefore ultimately this court has formulated the following substantial question of law by the order dated 13/8/2004. The learned counsel submits that the entire dispute relates to a portion of half katthas of land which stood jointly in the name of Hira Singh, Dasrat Singh and Anand Singh. So far as Hira Singh and Dasrat Singh are concerned, they have already transferred their respective shares to the plaintiff by registered sale deed, and there was an agreement of sale with Anand Singh, which is the subject matter of dispute in the present case. He has submitted that immediately after entering into agreement for sale, said Anand Singh sold.
Anand Singh and his son.
Sorry. They said Anand Singh and his sons sold 136 square feet by registered sale deed on 24/9/1997 to defendant second party, and 170 square feet to defendant third party by registered sale deed dated 27/9/1997. He submits that as soon as the plaintiff came to know about the aforesaid development, he filed the suit for specific performance.
No, prior to that suit was filed, thereafter amendment petition was.
Just a moment. The learned counsel submits that prior to the sale deed, the suit was filed and the aforesaid two sale deeds executed in favor of second party and third party was challenged by way of amendment. The amendment was allowed and defendant second party as well as third party had contested the suit. The learned counsel submits that in order to prove the agreement, the relevant witnesses were PW 2, 3, 15 and 17. PW 2 was the typist who had typed the agreement. He has also submitted that so far as DW2 is concerned, he was the son of Anand Singh, and he also had identified the signature of Anand Singh on the agreement. He has further submitted that there was another exhibit, namely Exhibit 6, which was the Wakalatnama executed by Anand Singh in another proceedings under section 107 of CRPC on the same date, and the said Wakalatnama was exhibited at the request of the defendants, and upon comparison it was found that the signature tallied with the signature of Anand Singh on the agreement. The learned counsel submits that the trial court found that after appreciating the materials, found that the agreement was valid and ultimately cancelled the two sale deeds dated 24/9/1997 and 27/9/1997 executed in favor of second party and third party and directed for specific performance of contract.
One correction also. In para 27 of the trial court judgment, it has been stated that प्रतिवादी द्वितीय पक्ष के विद्वान अधिवक्ता द्वारा कहा गया कि उनके पक्ष में तामील बैनामा प्रदर्श डी पर जट्टू सिंह का वादी व अन्य हस्ताक्षर है। इस हस्ताक्षर से इकरारनामा पर जट्टू सिंह के हस्ताक्षर का मिलान न्यायालय स्वयं करे तो स्पष्ट होगा कि जट्टू सिंह का हस्ताक्षर इकरारनामा प्रदर्श 1 पर जाली रूप से किया गया है। जिसके जवाब में वादी के विद्वान और अधिवक्ता के द्वारा कहा गया कि जट्टू सिंह का हस्ताक्षर जो दफा 107 प्रक्रिया संहिता के मुकदमा में दिए गए वकालतनामा प्रदर्श 6 पर जट्टू सिंह के हस्ताक्षर में मिलान किया गया है, क्योंकि प्रतिवादी प्रथम पक्ष प्रतिवादी 4 के साक्षी संख्या 2 गौतम सिंह जो DW2 है, जो जट्टू सिंह के पुत्र हैं, के द्वारा उक्त हस्ताक्षर को सही होना स्वीकार किया है।
The learned counsel has in particular referred to the discussion of the learned trial court at paragraph number 27 as to how and in what manner the signature of Anand Singh was compared and established in the agreement dated 13/3/1997 within bracket Exhibit 1.
And second point is that Anand Singh was not examined.
He was alive at that point of time.
He was alive at the time.
The learned counsel has also submitted that although Anand Singh was alive at the relevant point of time, but he was never produced as witness before the learned court. वो defendant होंगे?
हाँ, defendant was.
तो written statement file किए थे?
हाँ, written statement jointly हुआ था, उनका लड़का था.
He has submitted that the written statement was jointly filed by Anand Singh and his sons. उनके लड़के क्यों आ गए बीच में?
क्योंकि लड़के ही बेच दिए थे।
अच्छा. He has submitted that the sons of Anand Singh were made party in the proceedings as
during lifetime he had
as the sons had sold the property to second and third party during the lifetime of Anand Singh.
So one issue was framed also in this regard.
Appellate court क्या किया? Agreement को void बोल दिया.
हाँ, एग्रीमेंट को void बोल दिए और ये बोल दिए कि ये जो चूंकि प्रॉपर्टी बिक गया है, इसलिए इनको स्पेसिफिक परफॉर्मेंस का.
The learned counsel has submitted that so far as the learned first appellate court is concerned, the agreement was held to be void, and the learned first appellate court refused to grant any relief to the the first appellate court has upset the judgment of the learned trial court by observing that the property having already been sold, no relief under
Yeah.
specific performance act can be granted.
In violation of settled principle of law.
The learned counsel submits that the entire transaction by registered sale deed dated 24/9/1997 and 27/9/1997 was not only subject to list pendants but also subject to the agreement of sale dated 13/3/1997 within bracket exhibit.
Yes, two one judgment. In Guru Swami Nadar case,
ये वो सब केस बाद में, पहले अब तो आपका सारा बात सुन लिया, जजमेंट पढ़िए, सब्सटैंशिएट करिए अपने सबमिशंस को जजमेंट से, ट्रायल कोर्ट का इश्यूज दिखाइए.
ट्रायल कोर्ट का पारा 15 में इशू फ्रेम किया गया है.
पैरा 15
यह प्रस्तुत बात निश्चय के योग्य है.
रुक जाइए एक सेकंड. पैरा 15 पैरा 15 हाउ मेनी इश्यूज? 12 issues.
12 इशू है फ्रेम. इसमें 4 और 5 और वो आनंद सिंह और जट्टू सिंह के जीवन काल में ये पारा इशू नंबर 8 ये इम्पोर्टेंट है.
Issue number, so relevant issues would be issue number 8.
4 and 5 also. 4 and 5 is the main issue.
4, 5 and 8. पढ़िए जरा.
4 कहते क्या वाजपत में वर्णित तराजी में 1/3वां भाग के विक्रय के निश्चयवादी प्रतिवादी अनंत सिंह और जट्टू सिंह के बीच 25,000 रुपया दिनांक 13/3/97 को तय हुआ था और प्रतिवादी द्वारा 9,000 रुपया बतौर अग्रिम लेकर दोनों पक्ष के द्वारा दिनांक 13/3/97 को ही
This is on the legality and validity of the agreement.
whether any agreement for sale has been prepared or not and whether advance amount has been paid to. तो ये था. और इशू नंबर 5 है कि क्या वादी विक्रय संविदा के विनिश्चित अनुपालन के प्रावधान के तहत विवादी विक्रय वाली अराजी जट्टू सिंह का 1/3वां हिस्सा शेष संबंध 16,000 रुपया लेकर प्रतिवादी के पक्ष में निबंधित विक्रय तामील करने के लिए बाध्य करवाया जा सकता है.
Whether entitled to specific.
एक है कि whether the son of Jattu Singh is entitled to sell the property during the lifetime.
कौन सा?
8.
8. Just a minute.
उसके बाद से पारा 21 से पढ़ते हैं.
Just a minute. The learned counsel for the appellant has referred to the issues framed by the learned trial court at para 15, whose English translation is available in paragraph 5 of the impugned judgment. Impugned first appellate court judgment, which is quoted as under. He submits that the present case would be the issue number 4, 5 and 8 and 7.
7. Yes.
नहीं 7 and 8 ना 7 8 4 5 and 8
8.
are relevant for the present case. हाँ अब बताइए इसका फाइंडिंग कहाँ से पढ़ा,
पूरा जजमेंट पढ़ते हैं.
कहाँ से है 4 and 5?
4 and 5 से ये.
4 5 and 8 का फाइंडिंग कहाँ है?
8 का आगे 4 and 5 एक साथ लिया गया है पारा
हाँ ठीक है
24
4 and
से.
5 एक साथ हैं
पारा 24
और 8 and 9 एक साथ,
एक साथ.
ठीक है पढ़िए
पारा 24 आ गया.
हाँ यस प्लीज.
क्योंकि अनंत सिंह उर्फ जट्टू सिंह के द्वारा ही वादी के साथ अपने 1/3वां हिस्सा के विक्रय के निश्चित करारनामा तामील किया है एवं अनंत सिंह एवं उनके दोनों पुत्रों के द्वारा ही प्रतिवादी द्वितीय पक्ष के नाम से 136 वर्ग फीट तथा प्रतिवादी 4 के नाम से 170 वर्ग फीट जमीन फरोख्त किया गया है। इसलिए विवाद सिर्फ अनंत सिंह उर्फ जट्टू सिंह के 1/3वां हिस्से के जमीन को लेकर ही है। उक्त बिंदु पर सर्वप्रथम वादी के कथनों पर विचार करना ही उचित है। वादी द्वारा स्पष्ट वाद पत्र में कहा गया है कि प्रतिवादी 1 जट्टू सिंह के द्वारा जमाबंदी नंबर 603 में वर्णित 1.5 कट्ठा का 1/3वां भाग बेचने के बाद उनसे दिनांक 13/3/97 को 25,000 रुपये में तय किया गया। दोनों के बीच विक्रय संविदा हुआ। वादी द्वारा 9,000 रुपया बतौर अग्रिम के प्रतिवादी जट्टू सिंह को दिया गया। शेष रकम देकर दिनांक 12/3/1998 तक केवाला निबंधन करना तय था। उक्त तथ्य का एक इकरारनामा प्रतिवादी 1 एवं वादी के बीच संपन्न हुआ। यह इकरारनामा प्रदर्श 1 है। वादी उक्त इकरारनामा को विशेष अनुतोष अधिनियम की धारा 10 के तहत किया संविदा के विशिष्ट अनुपालन के प्रावधान के आधार पर विक्रय संविदा का अनुपालन कराने हेतु यह मुकदमा लाया है। वादी द्वारा यह स्पष्ट रूप से वाद पत्र के कंडिका 7 एवं 8 में कहा गया है कि वादी द्वारा कई बार प्रतिवादी 1 के यहाँ जाकर शेष जल संबंध राशि देकर केवाला करने का अनुरोध किया गया, परंतु प्रतिवादी द्वितीय पक्ष एवं प्रतिवादी 4 द्वारा प्रतिवादी प्रथम पक्ष को मेल मिलाकर उनके द्वारा तामील इकरारनामा को ढूंढिल एवं निष्प्रभावित करने की मंशा है। केवाला तामील कर लिया गया तो बिल्कुल ही अवैध है। वादी द्वारा उक्त तथ्य को लेकर स्पष्ट किया गया कि इकरारनामा के तामीला एवं गवाहों के बयान से सत्यापित करने के निष्पक्ष वादी संख्या 1, 3, 13, 15, 16 एवं 17
2, 3, 13, 15, 16
मेरा बहुत 2, 3, 13, 15, 16 एवं 17 16,608 एडवोकेट है साक्ष्य देकर सत्य सिद्ध किया गया है। प्रतिवादी प्रथम पक्ष एवं द्वितीय पक्ष एवं प्रतिवादी 4 के विद्वान अधिवक्ता के द्वारा वादी के उक्त तथ्य का जवाब कहा गया है कि वादी एवं प्रतिवादी 1 के द्वारा तामील किया गया तथा कथित इकरारनामा जाली, फरेबी, अवैध, निष्प्रभावी एवं शून्य दस्तावेज है। यह अनंत सिंह उर्फ जट्टू सिंह के द्वारा तामील नहीं किया गया है। इस पर उनका हस्ताक्षर नहीं है। उनके हस्ताक्षर को जाली बनाया गया है। साक्ष्य अधिनियम की धारा 102 के तहत वादी का यह दायित्व है कि इसे स्पष्ट रूप से प्रमाणित करे कि इकरारनामा पर वास्तव में जट्टू सिंह का ही हस्ताक्षर है। इस पर वादी के विद्वान अधिवक्ता द्वारा कहा गया कि चूंकि प्रतिवादी गण इकरारनामा पर जट्टू सिंह के हस्ताक्षर को जाली होने की बात कही है, इसलिए इसका लाभ उन्हें मिलेगा। फलतः उनका दायित्व है कि वे जट्टू सिंह के हस्ताक्षर का विशेषज्ञ से मिलान करवाकर वस्तुस्थिति स्पष्ट करेंगे, जो नहीं किया गया है। मैं उभय पक्ष के विद्वान अधिवक्ताओं के तर्कों पर विचार किया तथा उक्त तथ्य के आलोक में यह पुनः स्थापित सिद्धांत है कि जो व्यक्ति किसी तथ्य के आलोक में लाभ लेना चाहता है उसे ही उक्त तथ्य को प्रमाणित भी करना पड़ता है। प्रस्तुत वाद में प्रतिवादी गण के द्वारा जट्टू सिंह के हस्ताक्षर को जाली साबित कर लाभ लेना है, इसलिए उनका कानूनन उनका दायित्व है कि वे उसे सिद्ध करें। प्रतिवादी द्वारा इसे प्रमाणित करने विशेषज्ञ के यहाँ नहीं भेजा गया। जट्टू सिंह उर्फ अनंत सिंह जीवित है। वे स्वयं आकर कह सकते थे कि इकरारनामा पर उनका दस्तखत नहीं है, पर वे ऐसा नहीं कर सके हैं। इनके द्वारा जो उनके पुत्रों के द्वारा दाखिल उत्तर पत्र पर जट्टू सिंह का भी दस्तखत नहीं है। उनके रिटर्न स्टेटमेंट में जट्टू सिंह का भी उसमें भी नहीं है। रिटर्न स्टेटमेंट को फाइल के लिए उनको नहीं है। यह मुकदमा दायर किए 5 वर्ष होने को है। इसी बीच विशेष साक्षी के रूप में जट्टू सिंह आकर अपनी गवाही देकर वस्तुस्थिति स्पष्ट कर सकते थे, पर ऐसा नहीं किया गया है। प्रतिवादी गण द्वारा कहा गया है कि वे काफी वृद्ध हो गए हैं एवं चलने फिरने से लाचार है, पर किसी ने ऐसा नहीं कहा कि उनको सोचने समझने की सलाहियत नहीं है। प्रस्तुत वाद के निर्णय के लिए सबसे महत्वपूर्ण व्यक्ति जट्टू सिंह ही है। उनका नहीं आना यह सिद्ध करता है कि तथाकथित विवादित इकरारनामा उनका ही तामील किया। तो एडवर्स इन्फ्लुएंस विल गो हुआ, वे असत्य संभाषण करने न्यायालय में ही नहीं आए और न उत्तर पत्र जो विचरण के अंतिम क्षण में है दिया गया है पर अपना हस्ताक्षर नहीं किया। 27 इम्पोर्टेंट है। प्रतिवादी द्वितीय पक्ष के विद्वान अधिवक्ता द्वारा कहा गया कि उनके पक्ष में तामिल बैनामा प्रदर्श D1 पर जट्टू सिंह का वादी द्वारा मान्य हस्ताक्षर है। इस हस्ताक्षर से इकरारनामा पर जट्टू सिंह के हस्ताक्षर का मिलान न्यायालय स्वयं करे तो स्पष्ट होगा कि जट्टू सिंह का हस्ताक्षर इकरारनामा प्रदर्श 1 पर जाली रूप से किया गया है। इसके जवाब में वादी के विद्वान अधिवक्ता के द्वारा कहा गया कि जट्टू सिंह का हस्ताक्षर जो दफा 107 दंड प्रक्रिया संहिता के मुकदमा में दिए गए वकालतनामा प्रदर्श 6 पर जट्टू सिंह के हस्ताक्षर से मिलान किया गया है, क्योंकि प्रतिवादी प्रथम पक्ष प्रतिवादी 4 के साक्षी संख्या 2 गौतम सिंह जो जट्टू सिंह के पुत्र हैं के द्वारा उक्त हस्ताक्षर को सही होना स्वीकार किया गया है एवं प्रतिवादी साक्षी संख्या 6 संजीव सिंह के द्वारा कहा गया है कि दिनांक 13/3/97 को जट्टू सिंह का हस्ताक्षर इकरारनामा पर के हस्ताक्षर से मिलान के लिए ज्यादा सुसंगत एवं न्यायसंगत है, क्योंकि उसी दिन अर्थात 13/3/97 को ही जट्टू सिंह इकरारनामा पर हस्ताक्षर किए हैं और किए दोनों एक ही दिन किए हैं। मैं उभय पक्ष के विद्वान अधिवक्ता के तर्कों पर विचार किया एवं प्रदर्श A, प्रदर्श D एवं प्रदर्श 6 व गौतम सिंह के साक्ष्य का अवलोकन किया। यह बात सत्य है कि जट्टू सिंह के हस्ताक्षर के सही होने की सत्यता की जानकारी के लिए प्रदर्श 6 पर के हस्ताक्षर को ही न्यायसंगत समझा जाता है, क्योंकि दोनों हस्ताक्षर एक ही तिथि का है। प्रदर्श D पर का हस्ताक्षर उस वक्त का है जब मुकदमा की बात कही गई थी, इसलिए जट्टू सिंह से दस्तखत भिन्न ढंग से कराया जा सकता है, क्योंकि उनके पुत्रगण के क्रियाकलाप से ऐसा पता चलता है कि वे सब प्रतिवादी द्वितीय पक्ष एवं प्रतिवादी 4 के मेल में चले गए हैं। इस प्रकार प्रदर्श 1 एवं प्रदर्श 6 पर के जट्टू सिंह के हस्ताक्षर को मिलान करने पर दोनों एक जैसा हस्ताक्षर मिलता है, दोनों हस्ताक्षर जट्टू सिंह का है। इस प्रकार साक्ष्यों को विश्लेषण से स्पष्ट होता है कि इकरारनामा पर जट्टू सिंह का ही हस्ताक्षर है। प्रस्तुत वाद में प्रतिवादी गण के विद्वान अधिवक्ता के द्वारा विवादित इकरारनामा को जाली फरेबी बनावटी से निकालने के क्रम में यह कहा गया कि सर्वप्रथम तो इकरारनामा में जमाबंदी नंबर 603 का खसरा नंबर गलत दिया गया है, जिसकी वजह से विवादी अराजी का निश्चय नहीं किया जा सकता है। वादी को विवादी जमीन की वास्तविक जानकारी नहीं थी। उक्त इकरारनामा के आधार पर सारे जमीन की स्थिति स्पष्ट नहीं होती है। इस पर वादी के विद्वान अधिवक्ता के द्वारा कहा गया कि भू जमीन का निश्चयन उसके प्लॉट नंबर से नहीं बल्कि उसकी चौहद्दी से होता है, और इकरारनामा में दिया गया चौहद्दी के को किसी ने यह नहीं कहा कि यह चौहद्दी गलत है। यह सत्य है कि भूलवश इकरारनामा में प्लॉट के जगह एक जगह 470 के जगह पर 406 और दूसरी जगह 469 के जगह पर 406 470 के जगह पर 469 लिखा गया है। इस संबंध में वादी के द्वारा अपने साक्ष्य में भी स्थिति स्पष्ट किया गया है। दूसरी तरफ यह भी विवादी अराजी की चौहद्दी जो इकरारनामे में दी गई है उसकी पुष्टि प्रतिवादी के साक्षी संख्या 2 गौतम सिंह के साथ कंडिका 2 एवं प्रतिवादी 4 संजय सिंह के साक्ष्य के कंडिका 5 से होती है। इसलिए उक्त आधार पर इकरारनामा को जाली फरेबी नहीं समझा जा सकता है। मैं उभय पक्ष के उक्त तर्कों के आलोक में इकरारनामा प्रदर्श 1 एवं वादी हीरालाल केसरी के साथ साथ प्रतिवादी संख्या 2 एवं 4 के साथ का अवलोकन किया। उक्त अवलोकन से यह स्पष्ट होता है कि वास्तव में विवादी अराजी चौहद्दी के मुताबिक सही है और इसे किसी ने कोई चुनौती भी नहीं की है, इसलिए उस आधार पर इकरारनामा को जाली फरेबी नहीं है। फाइंडिंग दैट इट इज नॉट ए फोर्स प्रतिवादी के विद्वान प्रतिवादी के विद्वान अधिवक्ता के द्वारा उक्त इकरारनामा के जाली करार देने के क्रम में कहा गया कि उसमें जो स्टाम्प का कागज है उसमें 1-2 रुपये का है जो दिनांक 27/11/96 का है। दूसरा पृष्ठ में भी 2 रुपये का है जो दिनांक 5/7/70 का है और तीसरा पृष्ठ 1 रुपये का है जो दिनांक 3/7/70 का है और खरीदारी दिनांक 13/3/97 का है। इस प्रकार उक्त स्टाम्प इकरारनामा तामील होने के बहुत दिन पूर्व का है। यह एंटीडेटेड दस्तावेज पर एंटीडेटेड नहीं बनाया गया है, इसलिए यह दस्तावेज जाली और अवैध है। इसके उत्तर देते हुए वादी के विद्वान अधिवक्ता के द्वारा कहा गया कि स्टाम्प की खरीदारी में जो तिथि ऊपर लिखा हुआ है वह स्टाम्प वेंडर के द्वारा खरीदने की तिथि है, न कि वादी के द्वारा उक्त स्टाम्प दिनांक 12/9/397 को खरीदी गई और दिनांक 13/3/97 को इकरारनामा तामील किया गया है। इसलिए उक्त आधार पर इकरारनामा को एंटीडेटेड की बातें भी प्रतिवादीगण के द्वारा कभी नहीं कही गई है। न उक्त इकरारनामा पर दर्ज के स्टाम्प की स्थिति का अवलोकन किया। वादी का कथन सत्य है, उक्त आधार पर इकरारनामा को जाली फरेबी नहीं कहा जा सकता। प्रतिवादी के विद्वान अधिवक्ता के द्वारा उक्त इकरारनामा के जाली फरेबी और बनावटी होने के संदर्भ में कहा गया कि प्रतिवादी अनंत सिंह उर्फ जट्टू सिंह अपना जहाँ भी नाम लिखते थे वहाँ अनंत सिंह उर्फ जट्टू सिंह लिखा करते थे, न कि सिर्फ जट्टू सिंह। विवादित इकरारनामा में सिर्फ जट्टू सिंह लिखा हुआ है, इसलिए ऐसा इसलिए किया गया है कि जाल बनाने के क्रम में बहुत लंबा नाम लिखने में आसानी से पकड़ में आ जाती है, इसलिए उनके द्वारा अनंत सिंह इकरारनामा पर नहीं लिखा गया। यह भी एक ऐसी परिस्थिति उत्पन्न करता है कि विवादित इकरारनामा पर जट्टू सिंह का दस्तावेज बतौर जाल पे लिखा गया है कि पुष्टि होती है। उक्त बिंदु पर जवाब देते हुए वादी के विद्वान अधिवक्ता के द्वारा कहा गया कि वास्तव में प्रतिवादी संख्या 1 अनंत सिंह उर्फ जट्टू सिंह का प्रचलित नाम जट्टू सिंह ही है और स्थानीय लोग भी जट्टू सिंह का अर्थ मानते हैं। ऐसा जट्टू सिंह के पुत्र गौतम सिंह एवं गोविंद सिंह द्वारा तथा भतीजा संजीव सिंह जो प्रतिवादी के तरफ से साक्ष्य दिए हैं के द्वारा साक्ष्य में कहा गया। दूसरी बात यह है कि दफा 107 के आवेदन दाखिल करने के क्रम में दिए गए इकरारनामा
ठीक है, देखिए आगे 31 पढ़िए।
प्रतिवादीगण के द्वारा कहा गया कि उक्त इकरारनामा भी जट्टू सिंह के द्वारा तामील नहीं किया गया है, क्योंकि वो उस दिन जबकि दिनांक 13/3/97 को देवघर आए ही नहीं थे। लेकिन प्रतिवादी की साक्षी संख्या 6 संजीव सिंह और संभू सिंह की प्रथम साक्षी है कि साक्ष्य एवं प्रदर्श 6 से बिल्कुल स्पष्ट हो जाता है कि जट्टू सिंह दिनांक 13/3/97 को देवघर न्यायालय परिसर में आए थे और वहाँ वादी हीरालाल
ठीक है, ये भी हो गया।
ये हो
आगे
गया।
32
35 से इम्पोर्टेंट है, 32 भी थोड़ा देख लेते हैं। प्रतिवादी के विद्वान अधिवक्ता के द्वारा कहा गया कि इकरारनामा को सत्यता प्रमाणित करने के लिए उनके 2 सत्यापित करने वाले गवाह का साक्ष्य न्यायालय के समक्ष होना जरूरी है। इसमें सिर्फ एक ही साक्षी एज पर सेक्शन 68 ऑफ एविडेंस एक तो काफी है। गवाही का साक्ष्य न्यायालय के समक्ष होना जरूरी है। सिर्फ एक ही साक्षी इंद्रनाथ जजवाड़ी ये PW3 है की गवाही हुई है। इसके अलावा उनके द्वारा उक्त दस्तावेज में तामील को सही प्रमाणित करने के क्रम में वादी के द्वारा इकरारनामा को अंकित करने वाले कंटक सुनील कुमार दरिया से वादी साक्षी संख्या
इस पे तो कोई फाइंडिंग नहीं दिया होगा आपके लिए।
हाँ
एडवर्स फाइंडिंग
कोई एडवर्स नहीं है, तो क्या है कि है ही एक गवाह भी सफिशिएंट है, इस पर एविडेंस है।
नेक्स्ट
34 से शुरू होता है इनका फाइंडिंग।
33
हाँ 33 भी
वाद संख्या उसके बाद तो इन्होंने बोल ही दिया है कि इस वैलिड।
हाँ वैलिड, हाँ इकरारनामा वैलिड है, उन्होंने कह दिया।
32 हो गया, 34 ये 33 पड़ी।
33 कहते हैं प्रस्तुत वाद में वादी द्वारा यह निर्देश में किया गया कि प्रतिवादी प्रथम पक्ष के द्वारा दिनांक 24/9/97 को प्रतिवादी द्वितीय पक्ष के में एकरारित विवादी भूमि के अंश 136 वर्ग फीट के निस्बत कामिल निबंधित केवाला के को अवैध बिना जड़ सम्मन के निष्प्रभावी और शून्य दस्तावेज घोषित कर दिया जाए। ये मेरा वादी के विद्वान अधिवक्ता द्वारा उक्त विक्रय पत्र प्रदर्श D1 के निरस्त किए जाने के संबंध में कहा गया कि सर्वप्रथम यह विचार करना है कि वादी 1/3वां राजी जट्टू सिंह के जीवन काल में सिर्फ अनंत सिंह उर्फ जट्टू सिंह की अराजी है या उस पर उनके पुत्रों का भी हक या अधिकार है। उनके द्वारा कहा गया कि जट्टू सिंह के पुत्रों का पिता के जीवन काल में अराजी को बनाने का अधिकार नहीं है, जबकि इन सबों द्वारा बेची गई है। दस्तावेज प्रदर्श D1 पर जट्टू सिंह का हस्ताक्षर है, परंतु वे साक्ष्य देने नहीं आए हैं, जबकि वास्तव में वे ही विकृत वाली अराजी के मालिक हैं। उनका साक्ष्य देने नहीं आना यह सिद्ध करता है कि वे स्वेच्छा से नहीं बल्कि अपने पुत्रों के दबाव में दस्तावेज प्रदर्श D पर हस्ताक्षर किए। हस्ताक्षर को पहले के हस्ताक्षर से भिन्न बनाने के अस्वाभाविक रूप से हस्ताक्षर किया गया है। उनके हस्ताक्षर के समीप ऐसा लिखा हुआ नहीं है कि वे दस्तावेज के मजमून को पढ़कर या पढ़वाकर सुन समझ लिए हैं, वे हस्ताक्षर किए। ऐसी स्थिति में दस्तावेज सही जट्टू सिंह के द्वारा तामील नहीं किया गया है। इसका जवाब देते हुए प्रतिवादी द्वितीय पक्ष के विद्वान अधिवक्ता के द्वारा कहा गया कि उनका दस्तावेज जट्टू सिंह के द्वारा तामील किया गया, उसमें उनके पुत्रजन भी शामिल हो गए, तो उसमें उक्त दस्तावेज प्रदर्श D1 अवैध नहीं हो सकता। जट्टू सिंह वृद्धावस्था के कारण गवाही देने नहीं आए हैं। उनकी तरफ से उनके दो पुत्र गौतम सिंह और गोविंद सिंह तथा उनके भतीजा संदीप सिंह भी गवाही देने आए। उन्हें इकरारनामा के तामील नहीं करेंगे एवं प्रदर्श D1 तामील करने की जानकारी हुई है। उक्त दस्तावेज के विधिवत तामील किए जाने और जड़ सम्मन प्राप्त किए जाने की बात कही है। उनके नाम का बैनामा प्रदर्श D1 वैध एवं प्रभावकारी है। प्रतिवादी 2 एवं 3 उस पर पहले उनके किरदार के रूप में थे और मालिक के रूप में है एवं माँ चंचला फैब्रिकेटर्स नाम का ग्रिल वेल्डिंग का दुकान चलाया है। इस प्रकार वादी का तर्क अनावश्यक एवं असत्य है। प्रतिवादी नरेंद्र नाथ राव प्रतिवादी संख्या 10 के द्वारा उक्त तथ्यों के स्पष्ट रूप से साक्ष्य देकर संतुष्ट किया गया है। उस दस्तावेज को शैलेश कुमार गुप्ता प्रतिवादी साक्षी संख्या 9 एवं दूसरे साक्षी संजय सिंह के द्वारा साक्ष्य देकर बैनामा प्रदर्शन के तामील एवं जड़ सम्मन भुगतान का समर्थन किया गया। प्रतिवादी 2 एवं 3 को वादी एवं प्रतिवादी 1 अनिल सिंह और के बीच विक्रय संविदा होने एवं उसके निश्चय दिनांक 13/3/97 को इकरारनामा तामील किए जाने की जानकारी नहीं थी एवं खरीदने के पूर्व पता करने पर उन्हें यह जानकारी हुई कि उनके खरीदारी अराजी को कोई बैनामा या इकरारनामा तामील नहीं हुआ है।
You see, defendant number 2 and 3 were already in possession of the property, right? Defendant number 2 and 3 for second set and third set होंगे ना? They were already in possession of the property in the capacity of a tenant.
देख ले, मेरा भी वहाँ पर ग्रिल का ही दुकान है, हम भी वहाँ पर पहले से ही, उससे पहले से।
And further, they say that they were not aware about the agreement for sale. So the law protects a person who buys the property without notice.
नहीं, यहाँ पर तो ये आ गया है ना कि बाद में उनको पता चला, ये
बाद में पता चला।
हाँ, और वो कैसे पता चला है, फाइंडिंग में आया है कि संजीव सिंह को तो पहले से पता था।
कौन संजीव सिंह?
जो सेकंड परचेजर है।
अच्छा,
सेकंड वो भी आया है। मैं ओवर पक्ष के
नहीं, इसको ध्यान से पढ़िए। प्रायर नोटिस इज इम्पोर्टेंट, इसको ठीक से पढ़िए। You see, he has said that he had no knowledge.
हाँ, प्रतिवादी 2 एवं 3 को वादी एवं प्रतिवादी 1 अनंत सिंह और जट्टू सिंह के बीच विक्रय संविदा होने और उसके निश्चय दिनांक 13/3/97 को इकरारनामा तामील किए जाने का जानकारी नहीं थी।
हाँ,
ये बोलते हैं। एवं खरीदने के पूर्व पता करने पर उन्हें जानकारी हुई। खरीदने के पूर्व पता करने पर जानकारी हुई।
एवं खरीदने के पूर्व पता करने पर उन्हें जानकारी हुई कि उनके खरीदारी अराजी का कोई पैमाना या इकरारनामा तामील नहीं हुआ
है।
हाँ।
प्रतिवादी 2 एवं 3 के द्वारा वांछित जड़ संबंध देकर खरीद लिया गया है, उसका दस्तावेज।
Yes, ये बोल रहे हैं कि उन्होंने जो पहले भी पूर्व उन्हें ये जानकारी हुई, उन्होंने नेसेसरी इंक्वायरी की थी, उन्हें जानकारी हुई कि ऐसा कोई एग्रीमेंट नहीं हुआ है किसी के साथ. So they are completely denying notice in connection with this property. Yes.
That is their plea.
हाँ.
Yes. Now next paragraph. मैं उभय पक्ष के उक्त तर्कों पर विचार करते हुए उभय पक्ष के साक्ष्य एवं दस्तावेजी साक्ष्यों का अवलोकन किया। ऊपर यह सिद्ध हो चुका है कि दिनांक 13/3/97 को वादी एवं प्रतिवादी 1 के बीच जट्टू सिंह अपने हिस्से का जो कुल अराजी का 1/3वां भाग है के निस्बत किए विक्रय का संविदा वादी हीरालाल केसरी के साथ किए। प्रतिवादी द्वितीय पक्ष का दस्तावेज बनाया दिनांक 24/9/97 का है। कानूनन प्रतिवादी द्वितीय पक्ष को जो नहीं चाहिए था, प्रतिवादी नरेंद्र नाथ राव एक परचेजरी के साक्ष्य के कंडिका 3 से पता चलता है कि खरीदारी के पूर्व विवादी अराजी का स्थिति का पता लगाने सिमुलतला गए थे। सिमुलतला में रहते हैं थे पर वहां वे जट्टू सिंह से या उनके पुत्रों से पूछताछ नहीं किया, जबकि वास्तविक जानकारी देने वालों में जट्टू सिंह ही सबसे महत्वपूर्ण व्यक्ति थे। यह बात उनकी खरीदारी जमीन के निस्बत खरीदारी जमीन विक्रय संविदा का नामा के साथ उसी प्रकार उनके साक्ष्य के कंडिका 9 से पता चलता है कि जट्टू सिंह से उनकी मुलाकात सर्वप्रथम 1973 ईस्वी में एवं अंतिम बार दिनांक 24/9/97 को मुलाकात हुई। उसी दिनांक 24/9/97 को उनका दस्तावेज बैनामा तामील किया गया। उन लोग सीधे डायरेक्ट रजिस्ट्री कराते। उसी प्रकार उनके साक्ष्य से स्पष्ट होता है कि वे जट्टू सिंह से न तो विक्रय की बातचीत की और न तो अपनी खरीदारी अराजी की स्थिति की जानकारी थी। हालांकि ये साक्ष्य के कंडिका 10 में सतर्क होकर ऐसा कहा है कि इसके पूर्व उनकी मुलाकात दिनांक 1/9/97 को जट्टू सिंह से हुई थी, पर उस वक्त साक्ष्य का महत्व नहीं है। अपने पूर्व के साक्ष्य को धूमिल करने के गलत उद्देश्य से ऐसा कहा है। साक्ष्य के कंडिका 11 में से ऐसा पता चलता है कि वे खरीदारी के पूर्व वादी से मुलाकात किए, पर विवादी जमीन के निश्चित स्थिति का विक्रय इकरारनामा के बारे में स्पष्ट नहीं पूछा। उनके कंडिका 13 में कहा गया है कि वे सोनिया कुमारी के नाम विक्रय पत्र एवं रसीद देकर दस्तावेज लिख लिए। वादी के द्वारा कहा गया कि प्रतिवादी द्वितीय पक्ष एवं प्रतिवादी 4 के एक दूसरे के मेल। सोनिया कुमारी इज द मदर ऑफ जट्टू सिंह।
इसके कंडिका 15 में कहा गया है कि
कुमारी
सोनिया कुमारी के नाम
सोनिया कुमारी के नाम मदर ऑफ दिस जट्टू सिंह। The property belongs to Sonia Kumari, and Sonia Kumari had 3 sons, Hira Singh, Dasarath Singh and Jattu Singh. So एक 1/3 तीन लोगों का इनहेरिटेंस। तो वो बिक्री पत्र भी लगाया गया है। देखिए 10 वाली वादी के द्वारा कहा गया कि प्रतिवादी द्वितीय पक्ष एवं प्रतिवादी 4 के एक दूसरे के मेल में आकर एक षड्यंत्र के तहत वादी के द्वारा विवादी अराजी के भाग की खरीदारी की बात पक्की होने एवं उसके निस्बत इकरारनामा तामील होने की जानकारी के बाद भी वादी को परेशान करने के नियत से 3 दिनों के अंदर प्रथम प्रतिवादी द्वितीय पक्ष एवं प्रतिवादी 4 के द्वारा विवादी अराजी में 136 वर्ग फीट एवं 170 वर्ग फीट अराजी का निबंधन बैमान जट्टू सिंह के पुत्रों को मेल में लाकर लिखवा लिया गया है। मैं प्रतिवादी द्वितीय पक्ष एवं प्रतिवादी 4 के बैनामा प्रदर्श डी एवं ए का अवलोकन किया है। यह बात सत्य है कि दोनों दस्तावेज क्रमशः 24/3/97 एवं 27/9/97 का तामील किया हुआ है। प्रतिवादी द्वितीय पक्ष के दस्तावेज प्रदर्श D1 पर प्रतिवादी संजय सिंह के द्वारा गवाही बनाई गई है। संजय सिंह के द्वारा साक्ष्य में यह भी कहा गया है कि मैं अपने खरीदारी अराजी से प्रतिवादी द्वितीय पक्ष के यहाँ किराया पर दिए हैं उसके बाद में, एवं प्रतिवादी नरेंद्र नाथ राय द्वारा इसे स्वीकार भी किया गया है, जबकि किराएदारी का कोई रसीद पुर्जा नहीं है। इससे स्पष्ट होता है कि प्रतिवादी द्वितीय पक्ष एवं प्रतिवादी 4 के द्वारा जानबूझकर जट्टू सिंह के पुत्रों को मेल में लाकर बैनामा तामील करवा लिया गया है। ऐसी स्थिति में प्रतिवादी द्वितीय पक्ष का दस्तावेज पैसा नहीं है, क्योंकि जट्टू सिंह ने अपने हिस्से वाली जमीन को बेचने का हक सिर्फ उन्हें ही था, जिसे वे पहले ही वादी के यहाँ बेचने के लिए डाला था। सो क्वेश्चन ऑफ पोजेशन वाज नॉट प्रूव्ड। कोई भी किराएदार में थे या नहीं थे, न रसीद किए ना किए, और गवाही भी बोल रहे हैं कि खरीदने के बाद उनको किराए में दिए हैं, तो पहले से पोजीशन में नहीं थे। नाउ 35 इज इम्पोर्टेंट। प्रतिवादी के विद्वान अधिवक्ता द्वारा वादी के साक्ष्य के खंडिका 39 का हवाला देते हुए कहा गया है कि वादी स्वयं उनके दस्तावेज को मान लिए हैं, इसलिए यह विधि सम्मत है। साथ ही साथ माननीय उच्चतम न्यायालय द्वारा भी कहा गया कि बैनामा करने के बावजूद भी विक्रय किसी दूसरे पक्ष के यहाँ भी जमीन विक्रय कर सकता है। इसके समर्थन में उनके द्वारा यह 2002 हवाला दिया गया है। उनके निर्णय का अध्ययन किया, उसमें यह बात के तथ्य के अनुकूल साक्ष्य विवादी द्वारा विक्रय संहिता के विशिष्ट अनुपालन के लिए मुकदमा किया गया। प्रतिवादी तीसरे पक्ष के नाम जमीन निबंधित विक्रय पद से बेचने गया। वादी निबंधक के यहाँ केवाला नहीं करने का अनुरोध किया एवं अपने विक्रय संहिता की बात कही गई। इस पर विक्रेता प्रतिवादी द्वारा कहा गया कि इसके पूर्व ही विक्रय की बात तृतीय पक्ष से हो चुका था, इसलिए विक्रय पत्र के तामीला को नहीं रोका जा सकता। ऐसी स्थिति में माननीय उच्चतम न्यायालय द्वारा कहा गया है कि वादी को विक्रय संहिता के अनुपालन का डिग्री देने से इनकार कर दिया गया है। इस प्रकार प्रतिवादी द्वितीय पक्ष के उक्त निर्णय का कोई लाभ नहीं पहुंचता है। प्रस्तुत वाद में प्रतिवादी द्वितीय पक्ष के नाम शामिल किया गया बैनामा प्रदर्श भी उनके द्वारा ऐसे व्यक्ति से लिखाया गया अवैध दस्तावेज है, जो अपनी जमीन को उसके पूर्व ही बिक्री की बात पक्की कर 9,000 रुपया अग्रिम पाकर शेष रुपया लेकर निबंधित विक्रय पत्र तामील करने के निश्चय इकरारनामा तामील कर चुके हैं। उन्होंने विशेष अनुतोष अधिनियम के विक्रय संहिता के विशिष्ट अनुपालन के प्रावधान के एंड लास्ट लाइन इसी पैराग्राफ का द्वितीय पक्ष के बैनामा पर गवाही बनाई गई। इस प्रकार उन्हें उनके बैनामा की जानकारी थी, फिर भी एक षड्यंत्र के तहत उनके खरीदे अराजी 170 फुट अराजी को उन्हें परेशान करने के लिए खरीद लिया गया। यह बिल्कुल ही गैर कानूनी है। उनका दस्तावेज प्रदर्श ये निर्हा दिए जाने
कौन सा पैरा पढ़े थे?
उसी पैराग्राफ ये 35 में ही लास्ट।
इस प्रकार उनको जानकारी थी कहाँ है?
हाँ, जो बीच में भी है
इस प्रकार।
हाँ, इस प्रकार
ये नहीं वादी विक्रय संहिता के अनुपालन में इस प्रकार प्रतिवादी द्वितीय पक्ष को उक्त निर्णय का कोई लाभ नहीं पहुंचता है। प्रस्तुत वाद में प्रतिवादी द्वितीय पक्ष के नाम तामीला किया गया बैनामा प्रदेश D1 ऐसे व्यक्ति से लिखाया गया अवैध है, जो अपनी जमीन को इसके पूर्व ही बिक्री की बात पकड़ी कर कहाँ लिखा है कि जानकारी के बावजूद?
नहीं हम ऊपर कर रहे हैं। अर्थात यहाँ से शुरू कर रहे हैं। अर्थात 24/9/97 को प्रस्तुत वाद प्रतिवादी
कहाँ से पढ़ रहे हैं सर? प्लीज बताइए। मतलब लाइन नंबर बताइए। ऐसे
लाइन
कैसे
नंबर।
आप, ये बहुत इंपॉर्टेंट चीज पढ़ रहे हैं।
थोड़ा दिक्कत हो रहा है इसलिए कि मेरा
कुछ नहीं
ओरिजिनल
दिक्कत।
प्रिंट हो गया, मतलब टाइप करवाए तो थोड़ा
पेज नंबर 19 में ऊपर से पढ़िए।
90
प्रतिवादी तीसरे पक्ष के नाम जमीन निबंधित
के नाम जमीन ये तो जो पढ़ दिए हम
हाँ।
लेकिन यहीं से पढ़ दे रहे हैं फिर से।
हाँ,
इसी का लास्ट पैराग्राफ में
हाँ।
प्रतिवादी तीसरे पक्ष के नाम जमीन निबंधित विक्रय से बेचने गया। वादी में निबंधक के यहाँ केवाला नहीं करने का अनुरोध किया गया एवं उनके विक्रय संविदा की बात कही गई। इस पर विक्रेता द्वारा कहा गया कि इनसे पूर्व ही विक्रय की बात तृतीय पक्ष से हो चुका था। तो पहले से बात हो चुका था, उन लोग को जानकारी था, इसलिए
साथ में कमेंट मत
इसलिए
आप पढ़िए साथ
हाँ
में।
ठीक है ठीक है आई एम सॉरी। इसलिए विक्रय पत्र विक्रेता मीना के नहीं रोका जा सकता है। ऐसी स्थिति में माननीय उच्चतम न्यायालय द्वारा कहा गया है कि वादी को विक्रय संहिता के अनुपालन का डिग्री देने से इनकार कर दिया गया है। इस प्रकार प्रतिवादी द्वितीय पक्ष को उक्त निर्णय का कोई लाभ नहीं पहुंचता है। प्रस्तुत वाद में प्रतिवादी द्वितीय पक्ष के नाम शामिल किया गया बैनामा प्रदर्श DA द्वारा ऐसे व्यक्ति से लिखाया गया अवैध दस्तावेज है जो अपनी जमीन को उसके पूर्व ही विक्रय की बात पक्की कर 9,000 रुपया अग्रिम पाकर शेष रुपया लेकर निबंधित विक्रय पत्र तामील करने के निश्चय इकरारनामा तामील कर चुके हैं। उन्होंने विशेष अनुतोष अधिनियम की विक्रय संविदा के विशिष्ट अनुपालन के प्रावधान के तहत वादी के पक्ष से ही विक्रय पत्र तामील करने को बाध्य है। प्रतिवादी 2 एवं 3 का बैनामा अवैध एवं निष्प्रभावी एवं शून्य है, इसे निरस्त किया जाता है। प्रतिवादी द्वितीय पक्ष के द्वारा दाखिल अन्य कागजात सिर्फ प्रतिवादी द्वितीय पक्ष के दाखिल कब्जा में संबंध में है। इस वादी स्वीकार किए है, इसलिए इसका विश्लेषण करना आवश्यक नहीं है। वे किस हैसियत से यह स्थान नहीं है, पर वे दखलकार तो हम ही और अवैध दखलकार हो सकता है। 936 पैराग्राफ में वादी द्वारा कहा गया कि प्रतिवादी संख्या 4
नहीं अभी आप पढ़े थे ना वो।
हाँ वही 36 का ही है।
हाँ ठीक।
हाँ ये तो पढ़ चुके थे। द्वारा उनके विक्रय संविदा से संबंधित इकरारनामा वाली जमीन का 170 वर्ग फीट अराजी के उनके विक्रेता जट्टू सिंह का मुख्तारनामा के आधार पर तथा उनके पुत्रों को मेल में लाकर दिनांक 27/9/97 को एक दस्तावेज निबंधित बैनामा प्रदर्श से तामील करवा लिया गया है। उसे नाजायज बेअसर अवैध एवं निष्प्रभावी घोषित करना जरूरी हो गया। उनके द्वारा यह भी कहा गया कि उनका यह बैनामा मुकदमा दायर करने के पश्चात तामील करवा दिया गया है। वादी द्वारा यह कहा गया है कि प्रतिवादी द्वितीय पक्ष के नाम केवाला तामील के अधीन रजिस्टर के यहाँ भी आपत्ति किया गया। तभी इसी निबंधित स्थिति अर्थात 24/9/97 को प्रस्तुत हुआ प्रतिवादी 1 को अपने हिस्से का विक्रय संविदा वाली जमीन को उनके पक्ष में तामील करने को बाध्य करने के लिए वाद दायर किया गया। उस दिन यहाँ से उस दिन प्रतिवादी 4 संजय सिंह के द्वारा प्रतिवादी द्वितीय पक्ष के बैनामा पर गवाही बनाई गई। उस प्रकार उन्हें उनके इकरारनामा की जानकारी थी। फिर भी एक षड्यंत्र के तहत उनके खरीदने वाली अराजी के 170 वर्ग की अराजी को उन्हें परेशान करने के लिए भेज दिया गया। यह बिल्कुल ही गैर कानूनी है। उनका दस्तावेज प्रदर्श निर्हा किए जाने योग्य है। प्रतिवादी 4 भूमाफिया हैं। वे विवादी संपत्ति खरीदते हैं। प्रतिवादी 4 के द्वारा कहा गया कि वे उनके द्वारा सही दर संबंध देकर वे खरीदे हैं। उनका दस्तावेज वैध है। वे दस्तावेज तामील के पश्चात कब्जे भी दिखा पा चुके हैं। उसके बाद भी विवादी अराजी खरीदने का हक नहीं है। मैं उभय पक्षों के तर्कों को मद्देनजर रखते हुए विचार किया। उस पर यह सिद्ध हो चुका है कि वादी एवं प्रतिवादी 1 के बीच विवादी अराजी के विक्रय संविदा पक्की हो चुकी है एवं प्रतिवादी 1 के द्वारा 9,000 रुपया अग्रिम लिया गया है। इकरारनामा प्रदर्शित जट्टू सिंह और उनके पुत्रों को विवादी राजी का कोई भी अंश किसी को बेचने का हक कानूनी नहीं रह गया। यह तो प्रतिवादी 4 के बैनामा प्रदर्शित अंशों जट्टू सिंह के दस्तखत भी नहीं किए हैं। उनके तरफ से उनके पुत्र द्वारा व्यक्तिगत मुख्तार आम पे हस्ताक्षर किया गया है, परंतु न्यायालय के समक्ष कोई मुख्तार आम नहीं आया, जबकि जट्टू सिंह जीवित है। 3 दिन पूर्व प्रतिवादी द्वितीय पक्ष के केवाला पर दस्तखत करने आए हैं। उनका प्रतिवादी 1 के नाम प्रदर्श 1 पर दस्तखत करने नहीं आना और न ही आने का कोई विश्वसनीय कारण नहीं बताना यह सिद्ध करता है कि जट्टू सिंह नाजायज तामील नहीं करना चाहते थे, पर उनके पुत्रगण जिन्हें बैनामा
ये सिर्फ एग्जिबिट ए के बारे में बोल रहा है।
हाँ,
There are 2 सेल डीड्स ना?
2 सेल डीड्स है।
दूसरा सेल डीड के बारे में कहा?
हाँ, D1 है,
ए है। D1 के बारे में?
D1 में तो एक में केवल जट्टू सिंह के बेटे ये पावर अटर्नी लेके किया, हर एक में तो जट्टू सिंह के किए हैं, उनका बेटा को किया।
D1 के बारे में कहाँ फाइंडिंग?
D1 के बारे में हजूर पढ़े थे पहले।
हाँ, बस वही वो D1 के
हाँ,
बारे में।
27 पैराग्राफ में जिसमें कहा गया कि D1 के द्वारा
नहीं प्रीवियस नोटिस का फाइंडिंग कहाँ है D1 का?
प्रीवियस नॉलेज का
हाँ,
प्रीवियस नॉलेज का फाइंडिंग इसमें है। D1 के बारे में भी उसमें बोला गया है, उसी पैराग्राफ 35 में ही कि तामील किया गया बैनामा प्रदेश D1 उनके द्वारा ऐसे व्यक्ति से लिखाया गया है दस्तावेज जमीन को उनके पूर्व ही बिक्री की बात पक्की कर अग्रिम पाकर शेष रुपया लेकर निबंधित विक्रय पत्र तामील करने के निश्चित इकरारनामा तामील कर चुके हैं। उन्हें विशेष अनुतोष अधिनियम के विक्रय संविदा के विशिष्ट अनुपालन के प्रावधान के तहत वादी के पक्ष में ये विक्रय पत्र तामील कर।
एपिलेट कोर्ट का क्या फाइंडिंग?
Para 11 से I will start it from the
No, you
para
just come to the findings straight away. Para 11 ही है तो.
11
After
ही.
hearing. पढ़िए.
After hearing our learned counsel for both the sides and after going through the report, I find that none of the witnesses examined on behalf of the plaintiff has stated that he was knowing Jattu Singh and was identifying his writing and signature. The witnesses have only read the name of Jattu Singh on the agreement and have stated that this is the signature of Jattu Singh. The witnesses who have identified the signature of Jattu Singh have specifically admitted that they have no connection with Jattu Singh. PW2 Sushil Kumar Palesia has not even identified the signature of Jattu Singh and he has admitted that he does not know Jattu Singh. Similarly, PW3 Indranath Jajware has not stated that he was knowing the signature of and writing of the Jattu Singh from before, though he has identified the signature of Jattu Singh, but he has admitted that he has no connection with Jattu Singh, as Jattu Singh lives at Simantala, almost not at Dogan, and this witness does not go to the Simantala. Similarly, PW5 Balkuntha Pandey, who has identified the signature of Jattu Singh, has admitted that he had no concern with Jattu Singh and he had seen him only once in 1997 at Dogan and once at Simantala. He has तो पहले से तो जानकारी था ही और ऐसे जब फास्ट ग्रेड हो ऐसा तो जरूरी नहीं है. He has also not stated that he was knowing the
Exhibit 6 was the photocopy of a document. Photocopy से signature कैसे compare?
that was admitted as exhibit
So what?
without objection.
So what? Even if it was admitted as exhibit without objection, how the signature can be compared with Exhibit 6?
because the other side also has agreed with the fact that it can be.
So merely because there is an agreement, it can be done. दो आदमी के agreement से कुछ भी हो जाएगा क्या? But yes, DW2, his son has identified this.
हाँ, वो
उसका कोई discussion नहीं है इस finding में.
इसमें अपीलेट कोर्ट में उसको कम्प्लीटली ब्रश असाइड कर दिया
DW2 को.
DW2 और यहाँ पर उसके बाद नेक्स्ट पैराग्राफ में उसी पैराग्राफ में आगे लिख दिया
हाँ
है
ठीक है हम देख लेंगे.
कि
आगे बढ़िए.
in view of the fact that the sued property was sold to the dependent second party and third party for valuable consideration, the degree of his performance is possible.
12 बताइए. 12
this is
Para
the
12
पारा 11 में है.
वो हम देख लेंगे.
हाँ, उसके बाद पारा 11 में और भी है आगे. More so in view of the fact that the plaintiff has miserably failed to prove that the agreement of sale was executed in his favor in the fact or circumstances of the case.
This is the only ground.
Yes.
अच्छा आगे 12.
ये एक ग्राउंड की है. उसके बाद 12 में लास्ट 4 lines of 12. I find and hold that the registered sale deed executed by Anand Singh alias Jattu and his son in favor of dependent second party on 24/9/97 and in favor of dependent third party on 27/9/97 are valid and operating two documents. Accordingly, these issues are decided in favor of the dependents and against the plaintiff. Although no point of determination with respect to the point to be determined by the first appellate court has been formulated as I stated in para 8, which I had argued yesterday also. You remember para 8 of the judgment. And then after he took up issue number 6 and 7, and thereafter in para 15 issue number 1, 2, 3 and 12. And all these issues has been decided against the plaintiff by discarding the valuable evidence produced and brushing aside the evidence which is in favor of the plaintiff, just to reverse the finding.
This respondent.
One judgment out of 2 judgments, one judgment is of lis pendens, and second judgment what the first appellate court should do while reversing the judgment. That I am citing.
Yes, please.
Lord, I am appealing on behalf of respondent number 6. I have filed.
Who is respondent number 6?
Sanjay Singh.
Sanjay Singh. Who
Yes.
is the he was defendant number?
He was defendant number
Defendant number 4 or defendant's third party.
what?
यहाँ पर जजमेंट में आया
We
है
are appealing for this. He is defendant third party.
Third party. And second party for them they are giving a clarity on this.
We don't bother about it.
Yes.
आप अपना बहस करें.
Yes, ma'am. The issue, my lord, by the
Second party defendant. Second party is.
only one of them. Second, but that is Sanjay Singh. I have filed only on behalf of Sanjay Singh.
Okay.
Yes, ma'am. Lord, the learned
You are
appellate.
concerned with exhibit A or exhibit D by 1?
Lord, exhibit A is
Your deed is exhibit A.
first deed. that was in favor of mine, and thereafter it was in favor of the respondent number 8 and 9. Your Lordship may kindly peruse the appellate court judgment, Lord, while deciding Lord, paragraph number 9, Lord, issue number 4 and 5. It has been decided in para 11, Lord, that is internal page.
We have read it fully. अभी तो पूरा ही पढ़ना है. बताइए आपको क्या बोलना है उसमें.
Lord, the court.
Para 11 में
Yes.
evidence of DW2 has been considered, not considered.
Lord, as in
DW2 is the son of Jattu Singh. He is not an alien. He has identified the signature of Jattu Singh on the
Yes. Lord, while deciding that, Lord, may I read only para 11?
We have read it. आप बताइए क्या पढ़ना चाहते हैं.
Lord, that there a court has decided, Lord, the court below, Lord, in the between current, the court below has committed grave error in comparing the photostat copy of the signature of Exhibit 6.
गलत किया है. Exhibit 6 भूल जाइए. This whatever reason has been granted.
Yes.
Given with respect to Exhibit 6,
6.
there is no problem about it. That reason is absolutely correct.
And thereafter, this apart, the law laid down by the Honorable Supreme Court of India in so and so, Jagannath Sutra so and so is fully applicable in the facts of this case, in as much as in view of the fact that the suit property was sold to the defendant, second party and third party for valuable consideration. The degree of the specific performance of contract would not be granted to the plaintiff, more so in view of the fact that the plaintiff has massively failed to prove that the agreement of sale was executed in his favor. In these facts of the circumstance of this case, I am of the considered view that the plaintiff has massively failed to in proving the genuineness and legality of Exhibit 1, the agreement of sale allegedly executed in his favor. In that view of matter, the plaintiff cannot be held entitled to get sale deed. This is the pending plot. Now, while deciding issue number 8, 9 and 10, Lord, that is 12. Here also, Lord,
पहले आप इसका स्टोरी खत्म करिए. ये वाला para 11 का जो ये स्टोरी है ना, regarding genuineness of signature.
Yes. It was genuineness of the signature. So far, it's one of the, if the defendant has said that it is my father's
He is nobody. He is the.
Nobody, but he is the son.
He is the son.
Yes.
Yes.
There, from that point, there so far with the, it is an unregistered, that is not
required to be
but
registered.
signature,
97.
But that with that, they have taken. He was the tenant in that house,
उसके बाद भूल जाइए. आप खाली जट्टू सिंह के बेटे का एविडेंस बनाइए और बाकी सब बात भूल जाइए. We are not talking about anything else. You just talk about the evidence of the son of Jattu Singh, who has himself said that. Read क्या? This evidence which has been threadbare discussed by the learned trial court has not even been touched upon by the learned appellate court. The appellate court is absolutely silent on that. क्योंकि उनके पास इसका कोई जवाब नहीं है. The silence.
But considering all the other.
No, there is. It makes a judgment perverse. When the son is identifying the signature, who else is required to identify the signature? That is a stand-alone evidence on record. That too, he was coming from the side of the defendant.
Yes.
Then.
Not in cross-examination, yes.
And that is the only ground to hold that the agreement is invalid. So agreement sustains. अब उसके आगे क्या बोलना है बताइए?
Now if agreement sustains, Lord, the next issue, Lord, while deciding, Lord, the next issue, the learned appellate court, Lord, in view of the he is entitled for the amount he has received.
No.
Lord,
he is entitled to specific performance.
Yes, Lord. Lord, there are other. Lord, issue that is there are that I was reading, my lord, para issue number 8, 9 and 10. My lord, in this, while deciding para 12, my lord, all are the sons of Jatu Singh entitled to sell the suit property in the lifetime of Anand Singh. Is the registered sale deed number?
Is it an ancestral property? No.
Yes, it is the ancestral.
No.
It is the ancestral property of the father. It was purchased by the grandfather, my lord. It is the ancestral.
No. The property was standing in the name of mother of his.
Yes, yes. That it was mother of the my lord of Jatu Singh. It was purchased by the father.
By the mother of. Purchased by father कैसे बोल रहे हैं आप? उनके नाम से property है purchased by father.
Purchased.
Exemption.
नहीं. Purchased
the
by.
The property was standing in the name of the mother.
Mother. Yes. Mother of Jatu Singh.
Yes.
Yes.
That was her property.
Yes. That was her property.
Yes. It is not a co-pastory property. Yes.
But my lord, it is the property of the mother of Jatu Singh.
Yes.
And all brothers are entitled for.
Yes.
Lord,
Two of the brothers have already sold their share.
Yes.
Jatu Singh was to sell it.
Yes.
And for that purpose, he entered into an agreement.
Yes.
Right?
Yeah.
And during the existence of the agreement, Jatu Singh also joined with his sons and sold the property. Jatu Singh was one of the vendors.
My lord, yes. It is there, my lord. Sale of the suit property in the lifetime of Anand Singh.
Yes.
Are the sons of Jatu Singh entitled to sell the suit property in the lifetime of Anand Singh?
Yes.
Is the registered sale deed number so and executed by Anand Singh alias Jatu Singh and his 4 sons so and so in favor of defendant second said Narendra Nath Rao and so with respect of 17 feet by 8 feet in the suit property is a valid document or the same is illegal invalid document. While deciding this issue was as decided by the court below in favor of the plaintiff and against the defendant. It is an admitted fact that Anand Singh Jatu Singh has 4 sons who are also the defendant first party. It is also an admitted fact that the suit property earlier belonged to Sonia Kumari, alias Sonia Kumari, and her husband died leaving behind 3 sons, namely Hira Singh, Anand Singh and Dasrath Singh. This genealogical is admitted in the present suit. The sale deed dated so and so executed in favor of defendant second party by Anand Singh and his sons. Exhibit D by 1 in the suit, and the same has been executed by Govind Singh in his own capacity, as well as being the power of attorney holder of his father Anand Singh Jatu Singh, as also the other sons of Jatu Singh. The power of attorney executed by Anand Singh in favor of his son Govind Singh is not in challenge in the present suit. The plaintiff has claimed that both these sale deeds are same and inoperative transaction and they are without any consideration. In support of this case, the plaintiff has examined only himself on this point as PW 90. This witness has only stated his evidence that he learned from the reliable source that both the sale deed executed in favor of defendant second party and third party are invalid forced transaction. This witness has not stated at all in his evidence that the same were without consideration, and no evidence without whatsoever was being adduced by the plaintiff to show that the sale deed executed in favor of the defendant second party and third party are in any manner illegal. On the other hand, the defendant have proved the sale deed executed in favor of defendant second and third party and the same have been proved by DW2, Gautam Singh, Govind Singh, both of whom are the sons of Anand Singh alias Jatu Singh. DW1, Akshay Kumar Yadav, DW4, Sanjay Kumar Singh, the defendant third party himself, and DW5, Madhusudan Yadav, DW6, Sanjeev Kumar Singh, who is the son of Dasrath Singh and the vendor of the plaintiff, DW9, Sailesh Prasad Gupta, and Narendra Nath Rao, the defendant second party. In these facts and circumstances, I find and hold that the registered sale deed of so and so in favor of so and so are valid.
There is no doubt.
Yes.
It is a registered sale deed. It was duly executed.
Yes.
Let's take it.
Yes.
Right? But once the agreement of sale is valid, matter ends. That is the only finding recorded by the learned first appellate court. That the agreement of sale is not valid because the comparison was wrongly done, ignoring the evidence of DW2.
Milord, overall, there are other evidence also, Milord, showing that there was no such agreement, my lord. There are,
What are the evidence?
my lord, the evidence of the defendants and the other, my
I
lord,
mean
the
that the only
only part, there is
the
one line.
only plea taken
Yes.
by you before the court was that this is a forged document, it does
Yes.
not contain a signature.
Yes, full document.
And
But,
why did this Anand Singh did not come?
my lord, he had died, my lord.
No. He was very much alive, and in the written statement also, you just see his conduct.
Yes.
In the written statement also, he did not put his signature.
My lord, he was, my lord, most probably, my lord, he has died at that time. My lord.
नहीं
No.
अपीलेट में अपीलेट थे वो अपील भी फाइल किया
Through power,
उसके बाद
actually he was bedridden. Therefore, there was some
Bedridden
reason.
मतलब
Yes.
वो भी उसको भी डील किया.
Yes, that
Non-examination of Anand Singh is absolutely fatal.
he was examined through the power of attorney.
यहाँ
Lord.
पर-
He has given power of
Power
attorney.
of attorney क्या एग्जामिन करेंगे?
He has given that, my lord.
यहाँ
मरने के
पर
बाद तो पावर ऑफ अटॉर्नी भी खत्म हो जाता
खत्म
है.
हो जाता है.
तो फिर
सेकेंड अपील में डिलीट हुआ है आनंद सिंह का नाम
Yes.
क्योंकि उसके उस समय सेकेंड में फाइल करना कर दी
उस समय तक तो जीवित ही थे आनंद सिंह.
This is
The learned counsel for the appellant has
दो जजमेंट है इसमें
पैरा नंबर बताइए.
नहीं ये हम एक चीज बोला दूसरा चीज बोला चाहिए दो जजमेंट फर्स्ट अपील कोर्ट ने साइड किए हैं दोनों जजमेंट हम खोजे हमको मिला नहीं ये गलत साइटेशन डाला हुआ है. अब मेरा पैराग्राफ हम थोड़ा सा सर्किल कर दिए 14-15
कौन सा?
ये इसमें ये एक जजमेंट है जो ये वाले गुरुस्वामी के आधार में 14 और 15 है पारा 14 एंड 15 और एलन अश्वत्थामा वाला में पारा 8 है.
GW2 अब तक किस पैराग्राफ में एडमिट किया इनका सामने? पैरा नंबर बताइए.
तो निकाल देते हैं.
The learned counsel for the appellant has submitted that the learned trial court has considered each and every aspect of the matter while allowing specific performance of contract in the present case and by holding that the agreement was duly signed by क्या नाम है उनका? जट्टू सिंह.
जट्टू सिंह एलियस अनंत सिंह.
Anand Singh alias Jattu Singh has referred to the evidence of DW2, his son, and in paragraph number, the learned counsel has also submitted that Anand Singh never appeared before the court for his evidence, nor at the time of filing written statement put his signature. The learned counsel has submitted that the learned first appellate court, while holding that the agreement did not have the signature of Jattu Singh, alias Anand Singh, has referred to Exhibit 6, which was photocopied, but has completely ignored the evidence of his son, DW2, who had identified the signature of Jattu Singh during his evidence. He has submitted that the evidence of DW2 was enough to hold that the signature of Jattu Singh on the agreement was duly proved, and the evidence of DW2 has been considered by the learned trial court to hold that the signature contained the signature of The agreement contains the signature of Jattu Singh. The learned counsel submits that
Para 21
Jattu Singh had DW2 had stated in para 21 of his cross examination.
Yes, मौसम इतना वकालतनामा पर है वो, मेरे पिता का हस्ताक्षर है पैरा 21 में।
और भी है आगे
Like,
लिखावट मेरे पिता का ही है।
वकालतनामा
फिर कहते हैं फिर कहते हो तो लिखावट मेरे पिता की है, जमीन का माल हीरा सिंह पत्नी उसने कहा है कि हम न उसी उनके पिताजी का ही है।
ठीक नहीं है, वो नहीं कहें एग्रीमेंट पर है कहीं नहीं।
Exhibit 1/A was also marked without objection. Signature of Jattu Singh was marked without objection. He has also submitted that the signature of Jattu Singh was marked Exhibit 1/A without objection.
एग्रीमेंट बोला,
Agreement is Exhibit 1.
हाँ एग्रीमेंट पर जो है दस्तखत वाला है कहीं वो जो सिग्नेचर एडमिट किए हैं वो वकालतनामा पर सिग्नेचर पैरा 21 में एडमिट किया है कि वकालतनामा मेरे पिताजी का सिग्नेचर है।
नहीं, Jattu Singh का exhibit mark हुआ है इसमें. It has been marked.
उनका सिग्नेचर भी मार्क हुआ है।
हाँ, उनका signature mark हुआ है.
Not para 6 if you repeat DW2 below. Para 6 if you not some kind of मिलट मेरे पिताजी हीरा लाल केसरी से हुई द प्लेंटी मिलट जमीन बेचने का इकरारनामा नहीं किए हैं। इस इकरारनामा पर मेरे पिताजी का दस्तखत नहीं है। दिस इज द इस पर वादी के द्वारा आपत्ति प्रकट की गई है। Yes. अभी मेरे पिताजी का उम्र लगभग 80-85 वर्ष के हैं। अभी वे घर पर हैं। वे मधुमेह के रोगी हैं, चलने फिरने में लाचार हैं। मेरे पिताजी इकरारनामा के बारे में बातचीत हुई। वे कहे कि उक्त जमीन का इकरारनामा नहीं किए हैं। मैं चारों भाई एवं पिताजी मिलकर नरेंद्र राउत एवं द्विजेंद्र के पक्ष में दिनांक 126 वर्ग फीट जमीन 100 निबंधित केवाला से दलील से निष्पादित किए हैं।
On his admission, it was marked Exhibit 6, para 21.
Yes, yes. Yes, para 21 it is said, Lord, दिनांक 13/3/97 को वकालतनामा पर जट्टू सिंह मेरे पिता का हस्ताक्षर है। इसे प्रदर्शित संकेत, that is प्रदर्शित is the वकालतनामा of जट्टू सिंह। फिर कहते हैं कि उक्त लिखावट मेरे पिताजी का ही है। तकरारी जमीन का मालगुजारी कितना लगता है नहीं कह सकते हैं। तकरारी जमीन का मालगुजारी रसीद है पर that is exhibit 6 is the वकालतनामा मिला। That is वकालतनामा, not the agreement. That in para 6 he has denied the agreement and his signature.
Signature on agreement itself has been admitted. Exhibit 1 by 1.
That has been exhibited without objection.
That has been exhibited without, but that has not been admitted by DW2. It is not admitted.
तो objection करना था ना?
How objection? That was not. It has been marked as an exhibit.
No, without objection.
Yes,
Objection और no objection का बड़ा फर्क
Yes,
है ना?
yes, but it has been marked. But the fact that he has argued that it has
Yes.
been admitted
हाँ,
by
this is by PW2 is not, we are not able to get
DW2,
that.
it is not there in any
It
way.
is not there. He
Yes.
admitted the signature in wakalatnama.
Wakalatnama, and he has denied that there is any agreement.
Compared with the wakalatnama.
Compared, the court is not the expert. It has not been sent for expert evaluation.
It was for the defendant to.
No, defendant, it has to be proved by the plaintiff, signature to prove. That is the finding of the court, that plaintiff has to establish the agreement. He has not proved that signature on the wakalatnama and exhibit 1 is same. Plaintiff.
Who has asserted.
उसका डेट क्या है एग्रीमेंट का? 13/3/13। पैरा नंबर 40 पढ़िए। पैरा 40। पैरा 40 पढ़िए DW2।
से मेरे पिता
के दफा 107 का
107 का मुकदमा
हुआ
था। उसमें मुकदमा हुआ था नहीं कह सकते हैं। उस समय बाहर रहा करता था। मेरा आना जाना होता रहता था। ऐसी बात नहीं है कि मेरे पिताजी जट्टू सिंह ने हीरालाल केसरी वादी के यहाँ दिनांक 13/3/97 को अपना 1/3 हिस्सा बेचने की बात 25,000 रुपया में तय कर इकरारनामा किए थे, जिससे मैं रुपया मेरे पिता तौर पर भुगतान लिए बाद में उनके ये से खोट आ जाने के वादी के साथ बेईमानी कर लिया। ऐसा बात नहीं है। Denying this.
Just denying this. और उसमें किसने कौन सा पैराग्राफ 6 में बोला?
6 में बोला है कि कोई एग्रीमेंट नहीं।
The learned counsel for the respondent has also submitted that he has opposed the prayer and has submitted that the learned trial court has extensively relied upon Exhibit 6 by holding that the signature on the agreement was that of Jatu Singh. But at the same time, the appellate court has considered this aspect of the matter and found that Exhibit 6 was photocopy of the Wakalatnama filed in the proceeding under Section 107 of CRPC and has completely disbelieved the same and has found that such evidence could not be taken into consideration for comparison of the signature. The learned counsel has also submitted that the learned trial court had referred to the evidence of DW2, but DW2 had recorded that DW2 admitted the signature of his father on the agreement of sale, Exhibit 1, but from perusal of paragraph 6 of the evidence, he has clearly stated that his father had not put his signature on the agreement, and during his cross-examination also in paragraph 40, DW2 has clearly denied the suggestion about the entering into agreement by his father on 13/3/1997. The learned counsel submits that it was for the plaintiff to prove the agreement, but the plaintiff having failed to prove the agreement, that the specific performance could not have been granted to enforce the agreement itself. The learned counsel, on behalf of the appellant in response, has submitted that Exhibit 6 was taken into evidence on admission of the defendant number 2, as he had admitted in paragraph number
20.
paragraph number 21 that the Wakalatnama contained the signature of his father. He also submits that it was at the instance of the respondent themselves, the signature was compared, and it was held that by the learned trial court, and it was held that it was the signature in Exhibit 6 was tallying with the signature in the agreement. The learned counsel has also submitted that the signature of Jatu Singh on the agreement was exhibited without any objection, and therefore the signature stood admitted by the defendants. He has also submitted that the learned trial court has rightly drawn adverse inference for non-examination of Jatu Singh, and has also taken note of the fact that Jatu Singh had not even put his signature on the written statement filed before the court concerned, so as to completely rule out the scope of any comparison of signature. Nor Jatu Singh appeared as witness before the learned court. That's all.
But I only on behalf of respondent number 6, that may be noted, because others contesting, they are.
Everything is dependent on agreement only. I think.
Yes, yes,
अच्छा, respondent number 6 only है sir.
yes. Only
Rest
6.
of
I am
the-
the first purchaser.
Rest of the respondents are not there. You were
Sanjay
you were-
Singh.
Sorry.
In fact,
Defendant first party or second?
Second.
Second party.
second.
Defendant second party.
In fact, there is an order in this in the record itself that this appeal will proceed ex parte against the respondent because
No,
they
no,
are not
no.
appearing.
8 and 9 had appeared. 7 and 8 had
नहीं
appeared.
हम बता दे रहे हैं कि सतीश सर
1 to 5 has not appeared.
Ex party क्या है? Record है, record से
Record
decide
से-
करना है.
record पर-
Yes,
record
yes.
इसमें कुछ मतलब नहीं है. The
record
learned counsel for the appellants has
Yeah.
relied upon the judgment passed by the Honorable Supreme
one
Court
का delete हो
reported
गया
in
है, two-
bracket 2008 bracket close 5 SSC 796 para 14 and 15 and judgment reported in bracket 2009 bracket close 13 SCC 229 para 8. That's all.
The passing the judgment relied by the appellate court. Yes. That judgment we have received. He is saying that it is not known, but we have received.
देख तो 2000 सुप्रीम कोर्ट 1653 लिखा हुआ है वो कहीं है ही नहीं
आ गया अभी।
और दूसरा
दे-
का
हाँ, दे-
चेक नहीं
दे-
सबमिशंस आप लोग का लिखा ही लिए हैं.
Yes.
कौन दिया है इसका सबमिशन? सारा आप ही दिया है. आज टाइप हो पाएगा. ठीक है. आर्गुमेंट्स आर कंक्लूडेड पोस्ट फॉर डिक्टेशन टू कोर्ट पे लिखा देंगे. बस ये भी नहीं करना चाहिए. इतना पुराना केस है. कोर्ट पे लिखा देंगे. आपको आइए तो ठीक है, नहीं तो फिर एक हम जजमेंट किए थे संजीत जी, एक जजमेंट किए थे टाटा वर्कर्स यूनियन. कहाँ है वो जजमेंट? ये जो पैराग्राफ है ना, इसको कोट करो. नेक्स्ट केस को judges.
For final disclosure item 4, second appeal 354 of 2019.
उसमें डाल देंगे. किस पर जजमेंट है?
We relying upon this judgment, the appellate court has passed the order.
ठीक. You are there?
Yes, may I please your ladyship? Your ladyship, at the outset may I tender a brief written notice.
What is this about?
This is a tenancy landlord-tenant dispute. Your ladyship.
You are the landlord or tenant?
I am a tenant. Your ladyship. This was admitted on 28/11.
Tenancy is admitted
Yes, that is.
like
The matter was admitted on 28/11/2024. Thereafter, the sole respondent has died, and the legal representatives of the deceased sole respondent have been noticed through personal mode, but they have not appeared yet.
Okay. What are the points of law framed?
Pardon me,
What are the points? Substantial questions?
yes. Your Ladyship, the substantial questions
ये
of
तो
law,
judging आपको भी चाहिए.
page 3 of the written notes, I have reproduced the substantial questions of law.
No, that we have seen.
Yes.
Why do you want to rely upon 1996 6 SSC 222? Which
Yes.
paragraph are you
Your
relying?
Ladyship, before addressing Your Ladyship on the substantial questions, may I give a brief background?
I'll take that. Let me just understand. Right? 1999 6 SCC 222.
Yes.
Which paragraph and or for what proposition are you relying on? this?
Paragraph 14, Your Ladyship, for the proposition that alternative accommodation of the landlord was there, which has not been considered in this case, and that would have a bearing on the bona fide of the landlord.
Kindly read paragraph.
Yes. Paragraph 14, Your Ladyship, the availability of an alternative accommodation with the landlord, that is an accommodation other than the one in occupation of the tenant, wherefrom he is sought to be evicted, has a dual relevancy. Firstly, the availability of another accommodation suitable and convenient in all respects as the suit accommodation may have an adverse bearing on the finding as to bona fides of the landlord if he unreasonably refuses to occupy the available premises to satisfy his alleged need. Availability of such circumstance would enable the court drawing an adverse inference that the need of the landlord was not a felt need or the state of mind of the landlord was not honest, sincere and natural for this aspect of it.
And secondly,
Secondly, actually, that is in context of section 14(1) of the Delhi Rent Control Act. That may be applicable, but that is in context of section 14(1). May I read that part also?
just a minute. Another principal ingredient of the clause E of subsection 1 of section 14, which speaks of non-availability of any other reasonably suitable residential accommodation to the landlord, would not be satisfied. You read further, where another residential accommodation, read it please.
Yes. Secondly, another principal ingredient of clause E of subsection 1 of section 14, which speaks of non-availability of any other reasonably suitable residential accommodation to the landlord, would not be satisfied. Wherever another residential accommodation is shown to exist as available, then the court has to ask the landlord why he is not occupying such other available accommodation to satisfy his need. The landlord may convince the court that the alternate residential accommodation, though available, is still of no consequence, as the same is not reasonably suitable to satisfy the felt need, which the landlord has succeeded in demonstrating objectively to exist. Needless to say that an alternate accommodation to entail denial of the claim of the landlord must be reasonably suitable, obviously in comparison with the suit accommodation, wherefrom the landlord is seeking eviction. Convenience and safety of the landlord and his family members would be relevant factors. While considering the totality of the circumstances, the court may keep in view the professional or vocation of the landlord and his family members, their style of living, their habits and the background wherefrom they come.
So it is a general principle, it is not something which is peculiar to section. It is a general principle.
Your Ladyship, there is one difference if compared with the BBC Act, that at the end of section 14(1) of the Delhi Rent Control Act, it also mentions that where the landlord has no other reasonably suitable residential accommodation. This is specific to 14(1), which is not there in section 11(1)(c).
So that's reasonably
Yeah, but that
comparable
a
is
general
always
principle.
there.
That is a general principle.
That is a general,
General
principle.
principle.
Right? You can't ask a landlord to shift to a place which is absolutely not suited to him.
Yes, that is the least danger. That is
Right.
the general principle.
So that is a general principle. So you just can't exclude any one of them. Anyways, this is para 14.
Paragraph 14.
Okay. What is the other one? Other one is for what?
Other one, the second question of law, that is 2022-3, that there is no independent consideration of independent reasoning by the learned courts below.
This is which paragraph? Which paragraph?
60 and 62 variation.
Para 60 and
62.
62.
May I read the relevant parts, Your Ladyship?
Yes, please.
Paragraph 60, Your Ladyship. I'm reading the relevant part, page 2.
You read fully.
The whole. Before parting with this case, we would like to reiterate that in this case, the High Court has dealt with the judgment of the learned trial judge in a shortcut method, benefit of all reasoning while reversing the judgment of the trial court both on facts as well as law. It is tried that the appellate court has jurisdiction to reverse, affirm, or modify the findings and the judgment of the trial court. However, while reversing or modifying the judgment of a trial court, it is the duty of the appellate court to reflect in its judgment conscious application of mind on the findings recorded supported by reasons on all issues dealt with, as well as the contentions put forth and pressed by the parties for decision of the appellate court. Now this part is no doubt, when the appellate court affirms the judgment of a trial court, the reasoning need not to be elaborate, although
That's it. This is settled principle. Now, let's see your judgment.
may I give a background of the matter, Your Ladyship?
Yes.
Yes. This is the judgment of concurrence, Your Ladyship. The plaintiff landlord had filed a suit for eviction on grounds of personal necessity as well as default. The learned trial court decreed the suit on grounds of default as well as personal necessity.
Just a moment.
Yes.
It was ground was default
Default and personal necessity.
and personal necessity.
Yes, Your Ladyship.
Okay.
The learned trial court decreed the suit on both the grounds, but the learned first appellate court reversed the finding of default, holding that the tenant is not a defaulter, but affirmed the finding of personal necessity.
The landlord had an alternative
Yes.
accommodation.
Yes.
Was that specific plea taken by you before the learned trial court?
Yes.
Where is that pleading?
Yes.
And where is that discussion?
Yes.
Was any specific issue framed?
Your Ladyship, there was one issue regarding personal necessity. That was the only issue, and no
Issue
separate
number?
issue. Issue number, Your Ladyship. Page 30, running page 38.
Yes,
Issue
I'm
number
there.
7. Whether the plaintiffs have required the suit premises reasonable and good faith for their own use and occupation and personal necessity.
Where is the discussion by the learned trial court
Yes.
on issue number 7 and 8? You just referred to 7 and 8.
Your Ladyship, the internal page 11 of the learned trial court judgment, the findings. Before that, the trial court discusses the evidences.
Okay. Issue number 5, 6, 7, 8.
Page 10 and 11 are the findings.
Para?
Your Lordship, page, internal page 10, the last para, that is in documentary evidence. From there, the findings begin.
Just a moment. The point was that family members of the plaintiff have enormously increased
Yes.
and all of them have become adult.
Yes.
As such, there is scarcity of accommodation. As such, the tenanted premises is urgently required to the plaintiff for his personal bona fide requirement and in good faith.
Yes.
Right?
Yes.
So the premises in which the landlord was living was adjoining to the tenanted
No,
premises.
so the suit premises is a two-storied building as per the case.
Okay.
In the ground floor, the tenant was living. There was a upper floor also in which there were other rooms in which other tenants were living. And the landlord was living in a different house which was about 50 meters away from the suit premises. And that house is also a two-story house. That has come in evidences in cross-examination of the plaintiff witnesses. then showing the written statement and the depositions.
No, just a moment. You just come to the witnesses have come. Then where is the case of the defendant regarding personal availability of alternative accommodation? On the other hand, the defendant has examined the case of the defendant in the written statement, para 9.
Yes.
This which portion deals with the alternative,
Um,
the personal requirement.
yes. In paragraph 11 of the WS we had taken. In internal page 9, your ladyship.
No, you just read it from the interim judgment itself. Internal page 9.
Yes. Internal
The
page.
personal requirement.
Yes.
Hmm.
Very that.
Yes.
Yes. Internal page 9,
Yes.
7th line from the top.
Yes.
So, 6th line. The personal requirement of the plaintiff shall not be considered in the present suit. Several portion of the building premises adjacent not to the tenanted premises and occupation of the defendant, and 2 more flats of upper floor of the building are vacant at this moment, have caused disentitlement of any decree for personal necessity of the present plaintiff. Defendant has invested, thereafter it is coming that they have invested huge amounts.
Then what is the finding of the learned trial court?
Yes, that begins on your leadership from page 10, the last paragraph. May I read?
In the light of the above facts. Read it, please.
From which part your leadership?
Page 10, para last portion.
Yes. In documentary evidence,
Nay, in the light of the above facts and circumstances. Last line.
in the light of the above facts and circumstances on the perusal of the oral and documentary evidence, it transpires that in the written statement and examination chief, and also cross-examine the DWs, they have admitted the fact that they are the tenant of Ajit Kumar Gupta. They have stated in their cross-examination that the rent was paid by the defendant to the plaintiff in cash as well as money order. The defendant has admitted the existence of relationship of landlord and tenant between the parties. The plaintiff has produced and exhibited the document regarding the ownership of the suit property. Defendant failed and neglected to pay the monthly rent on and from the month of May 1995 and deferred the matter on various pretexts. And lastly, on 10/12/2005, he refused to pay the house rent arrears as well as current rent to the plaintiff in spite of repeated request and demand of the plaintiff. The suit premises is required for the bona fide purpose of plaintiff, as because the family members of the plaintiff have enormously increased and all of them have become adult. As such, there is scarcity of accommodation. So the partial eviction will not meet the requirement of plaintiff. Plaintiff further proved that the defendant is a defaulter toward payment of rent from May 1995 and defendant has failed and neglected to remit the monthly rent at rupees 1100 per month in spite of repeated requests and demand. The arrears of rent due since January 2003 to December 2005 at the rate of rent of rupees 1100 per month, total 36 months at total rupees 39,600 mentioned in Schedule B of the plaint. Thus, the defaulter is defaulter. Therefore, the plaintiff has entitled to get the suit premises from evict the defendant. Hence, issues are decided in favor of the plaintiff. So this is
Which witness of the defendant has stated the availability of alternative?
all the defendant witnesses have consistently stated about alternative accommodation. And may I also point from the cross-examination of the plaintiff witnesses? Defendant number 1 in paragraph 11 of his examination in chief, he has stated. 2, 3, 4 also have stated in similar lines about availability of alternative accommodation.
evidence they produce against you. You just tell us which witness has said
Yes.
about the availability of
Yes.
alternative.
In paragraph 3 of the written notes, I have stated which witness has stated and in which paragraph. Page 3 of the written notes. From the bottom, there is a list. PW2 plaintiff has stated in paragraph 5 of his cross-examination that the suit premises two-storied having more than 10 rooms. In paragraph 21 of the cross, he has stated that there are other tenants also. In paragraphs 25 and 27, he has stated that he is living in another house which is also two-story. And PW3 has stated in paragraph 6 of his cross that the suit premises two-story. Paragraph 11 of his cross that the defendant lives in the ground floor. And a Gujarati female
No,
lives in.
where is it that there are vacant accommodation?
Your Ladyship, in the defendant witnesses have stated that in their examination in jail. And in
But you have not cross-examined any of the witnesses of the plaintiff so far as vacant accommodation is concerned.
vacant, they are saying that upper floor there are rooms in which other tenants are living.
Yes.
And,
What about the vacant accommodation that it is available?
vacant has not come in the cross-examination of the plaintiff witnesses. They have stated that there are other tenants. PW2 has stated there are other tenants. PW4 has stated that there are 4 other tenants apart from the defendant. And PW3 has stated about a Gujarati female living in the upper floor as a tenant.
Which defendant has talked about empty rooms? It is empty rooms or other tenants.
They are saying that empty
Or
rooms
it is
are other
absolutely
tenants.
vague.
But it has come in the plaintiff witnesses cross-examination that there are other tenants.
Other tenants would be there,
But empty,
but
has-
empty rooms, because
that
when
is
you are
not-
talking about availability of alternative accommodation, then that accommodation should be empty rooms.
But there is one more angle to this that there is another house which is also two-storied in which the plaintiff is living.
So
So that is also available
that
to
is
plaintiffs.
so that is there. That is his house. He may have number of houses. We do not know how many members are there, but you have to show you have taken a plea that empty rooms were available. Now show me which witness has said that empty room was available, and how many empty rooms were available.
That has not come.
So-
How many empty?
And therefore even the partial eviction matter has been rejected.
That has not been considered. There is
But
no
that there
discussion.
is no, it has been considered, and there is no substantial question of law on that point.
There is no contact.
So I just want to know that two things you have to prove when you say that he has an alternative accommodation. One is the accommodation is available. Secondly, it is sufficient.
Ladyship, firstly, it was upon the plaintiff to at least prima facie prove that he needed the
It is
space
not in
for
dispute
the-
that he needed the property on account of number of family members had become major. This is not in dispute.
But that there is only an assertion and bold statements in the depositions, only 2 bold statements. He has not sufficiently proved that he required those premises, that it was a genuine need. Where rely upon a
The entire judgment is based on alternative accommodation. Need is already there.
but if the need has to be proved, and the plaintiff has not been able to prove the need. If I may cite one judgment on this. Paragraphs 14, 15 and 17.
Yes, please read it.
Yes. Paragraph 14. The phrase bona fide requirement or bona fide need or required reasonably in good faith or required occurs in almost all rent control acts with the underlying legislative intent which has been considered and demonstrated innumerable times by various high courts as also by this court, some of which we would like to refer to. In Ramdas versus Ishwar Chandra, it is said that the bona fide need should be genuine and honest, conceived in good faith. It was also indicated that the landlord's desire for possession, however honest it might otherwise be, has inevitably a subjective element in it, and that desire to become a requirement in law must have the objective element of a need, which can be decided only by taking all the relevant circumstances into consideration so that the protection afforded to a tenant is not rendered illusory or whittled down.
You
Paragraph
see, the moment you take a plea that landlord has an alternative accommodation, the need stands in.
That is one aspect, that alternative accommodation, availability of alternative, that has an impact on the bona fide of the plaintiff. But he has to sufficiently prove that he genuinely needed the suit premises is also an aspect that we require consideration.
The only substantial question of law in this connection is,
First is regarding alternative accommodation.
can we read first one?
The first is whether the learned first appellate court has committed perversity by not considering the bona fide of the landlord in not occupying the alternative accommodation,
Yes.
and whether the landlord unreasonably refused to accept the alternative
That's
occupation.
So his need is not in question in this particular substantial question. His need is admitted, but the point is whether the alternative accommodation was available and whether the alternative accommodation was sufficient. So need is not under question. Need is there.
But that had to be proved, and the
You
learned
see,
courts will have
in second appeal, we have to confine ourselves to the substantial question.
one more thing regarding second substantial question of law. The learned courts will have to look at, or had to at least independently see whether he was able to show
That is separate. We have to see. Let us see the findings of the learned first appellate court.
Yes. There are 2 points for determination that were framed.
There is
That is at running page 23, internal page 8. The first was regarding default and second was regarding personal rules.
default, forget it.
Yes.
Now,
Second one was whether the plaintiff/respondent required the suit premises for his own occupation and personal use. And the finding is that your ladyship, internal page 15, your ladyship, the findings.
you just read from here.
Which one?
Just a minute. Page number 11. There was about 20 meters courtyard in the house, right? Then you just come to the bottom. No room is vacant in the suit premises. In the upstairs of the house of Mohanlal Chauhan. Who is Mohanlal Chauhan? In the upstairs of the house of Mohanlal Chauhan lives with his family. But Lal Solanki also lives there. Presently, he is residing with his family in another house near DAV School, Katras. Mahesh Chandra Gupta has supported the case of the plaintiff and further states that his house is about 200 to 250 yards away from the disputed property which belongs to Ajit Kumar Gupta. Ajit Kumar Gupta has 4 brothers. One of his brothers has died. Who is the plaintiff?
The plaintiff is Ajit Kumar Gupta, the PW2.
You read para 13.
Paragraph 30.
You can omit the portion of default.
Page 14 of paragraph 13 is mostly with respect to default.
Okay, let's forget it.
Yes. Page 15.
ये para 14.
उसके ऊपर भी leadership there is a finding on personal necessity. From the top, 4th line, from there. It is held that the tenant slash defendant is not defaulter in payment of rent, but the plaintiff slash respondent needs the suit premises for his own occupation. Only because of alternative accommodation is available to the landlord. It does not mean that the requirement of the landlord has been fulfilled. The court has to consider and decide the bona fide requirement of the landlord, and the reliance may be placed upon the case of Ramdani Sahu versus Vidya Devi. The partial eviction would not serve the purpose of the plaintiff, as based on assessment of the evidence. The reliance may be placed upon the case of Shyamlal Kedia versus Rajesh Kumar Tekriya, and also on the case of Aryan Trading Agency through its proprietor. Thereafter, paragraph 14, on the basis of above discussion, it is held that the defendant slash appellant is not defaulter in payment of rent, but as far as the requirement of plaintiff of the suit property is concerned, there is evidence on record to prove that the plaintiff slash respondent needs the suit premises for his bona fide and personal requirement. The defense slash appellant is ordered to pay the arrears. Yes, thereafter, both the points for determination are decided accordingly. Leadership, there is finding, but there is no reason to support the finding. Bona fide has also not been considered. Alternative accommodation, the significance and what all were available, that has also not been considered. Whether the current house was not sufficient for the landlord, that is also not being considered.
You were talking about bona fide availability of alternative arrangement or alternative accommodation in the suit premises itself.
No, it's overall relation,
Sorry?
not in the suit premises.
It was
Alternative accommodation in the sense that he is living in a house presently living in a house which is 50 meters away from the suit premises and which is a 2-story house.
Okay.
So prima facie, he had to show that that is not enough for him. He has made a statement, averment in the plaint, supported by 2 statements. But there is no specific thing that is not enough for him.
You see, that is not the point of law. The point of law as to whether there was availability of alternative accommodation, isn't it? Now, this quote in paragraph number 11, in page number 11, who is this? No room is vacant in the suit premises. Who has said this? Because your entire case was that in the suit premises itself, in the first floor, there are vacant rooms and.
The defendant witnesses have stated that either vacant rooms or other tenants. Other rooms are there, that is not disputed. But there are other tenants or vacant, that has.
So there is no clear statement that there are vacant rooms in the suit
But
premises.
admittedly, there are other rooms in which, as they have stated, that there are other tenants.
There are other tenants. And who is saying this? No room is vacant in the suit premises, para number 11, page
That-
number 11.
The plaintiff witness too, it appears, because at the end of page number 10, the
Yes.
court has started discussion on the statement of PW2.
He is the himself, he is the plaintiff
Plaintiff.
himself.
Yes,
Yes.
he is the plaintiff himself. PW2, Ajit Kumar Gupta is the plaintiff, and thereafter the discussion on his
Yes, and he has stated that no room is vacant in the suit premises.
no rooms are vacant. There are other tenants.
You just read further, and you read it.
PW2 Ajit Kumar Gupta is the plaintiff. He has stated about the case in detail in his examination in chief, and further states that he cannot say about the area of the suit property. There was about 20 meters courtyard in the house. Suit property was purchased by his father. There are altogether 6 rooms. Anand Gupta and Arun Kumar Gupta are his brothers. The defendant has taken the suit property on rent in the 1992. He has given rent receipts till April 1995. Before that, he has never given any rent receipt. There was no partition among them for the suit property as per section 2 of BBC Act. Landlord includes the person who for the time being is receiving or entitled to receive the rent of the building whether on his own account or on behalf of another, or on account or on behalf of for the benefit of himself and others, or as an agent, trustee, executor, administrator, receiver, guardian, or who would so receive the rent to be entitled to receive the rent if the building were let to a tenant. It is not necessary that the landlord necessarily be the owner and title holder of the building. A person who collected rent for the time being, whether on his own account or account of another, shall be the landlord and is entitled to maintain the suit for eviction. Reliance may be placed in the case of Rajat Prashadi Manohar Lopar. His father died on 29/1/91. He has never received any money out of loan and is vacating the suit premises. In the upstairs of the house, late Mohanlal Chauhan lives with his family. Barpulal Solanki also lives there. Presently, he is residing here as a plaintiff. He is residing with his family near DAV School, Katras. Mahesh Chandra Gupta, thereafter PW3's discussion.
So there is enough discussion.
But there had to be, in addition, this had to be considered by the courts on application.
It has been considered.
This is the statement, Your Ladyship.
No, you see, he's saying about it. Is this recording of evidence incorrect?
This is correct. Recording of
Yes.
evidence is
And
correct.
then this our first appellate court is referring to the discussions and there is evidence on record that there is evidence. He has discussed the evidence and he is talking about the evidence. This evidence is there.
This evidence is there, but the point, Your Ladyship, is that there is no independent application of mine that
You said there is no vacant room. Your case was that in the suit premises itself there are vacant rooms on the first floor. When you talk about alternative accommodation, you have indicated the alternative accommodation, right? And your witnesses have also not made any definite statement as to whether which room is vacant. He has made a definite statement that no room is vacant in the suit premises. He has also stated that who are living in the first floor and second floor or whatever. Then,
But Your Ladyship, the alternative accommodation would also subsume within itself the house in which he was living.
that is not, he is already living.
But was that sufficient or not was one thing that.
No, that whether it was sufficient or not is not in dispute. That it is not in dispute that it was insufficient. The question of law is only with regard to availability of alternative. Sufficiency is not in dispute. It was insufficient. The question of law is only as to whether there was alternative accommodation available.
Your Ladyship, I would say that this relates to the finding of bona fide of the landlord so far as his need is concerned. As had been mentioned in the by the Honorable Supreme Court, there has to be an element of genuine element of need, and that has to be objectively looked into. So whether that has been objectively looked
You
into, or
said he has 4 brothers, there has been no partition, there are so many family members. It is already stated so.
there are family members, but the family members who are living in the house in which he is presently living, that had to be proved that there are many family members, and that is that aspect. On that aspect, I would say that this suffers infirmity and perversity. And regarding
So, do you want to say that even the finding of default is incorrect? Default has been thoroughly discussed and decided in your favor,
default has been discussed,
fully discussed.
that has been discussed initially.
So, if we answer substantial question number 2, then the entire judgment has to go, even on the point of default. You demonstrate that this order 41 rule 31 has not been satisfied. He has framed the point of determination. He has considered the evidences on record. He has considered the contested points.
So far as default is concerned, if your Ladyship may kindly have internal page 10 of the first appellate court judgment. Default has been discussed in page number 10. But in page 11, there is nothing, no reasoning. Then he has discussed, the learned appellate court has discussed the evidences. He has reproduced the evidences. But in page 11, there ought to have been some reasoning, at least some reasoning as has been in the Honorable Supreme Court. Page 10, default has been discussed.
Page 11, this requirement and non-availability of vacant premises in the suit premises is also discussed.
And by the learned first appellate court, your Ladyship, internal page 14 of the learned first appellate court, default has been discussed, but page 15 there is no reasoning regarding personal necessity. So there had to be some reasoning as has been made by the Honorable Supreme Court. He comes to the learned court comes to a finding that he requires the suit, but at least some discussion, some reasoning that could not have been dispensed with. And may I also give a recent judgment of this Honorable Court. One judgment of this, of the division bench of this Honorable Court. Regarding reasons to be
In writ,
Your Ladyship, the principles of reasons have been stated.
principles of reasons has to be.
Paragraph 3 onwards. May I read paragraph 3 onwards?
That's right. That's right, reasons has to be.
Yes. But there is no reason whatsoever regarding personal necessity. Order 41, Rule 31 also says that reasons have to be there. And also on the point of how many tenants are living in the upper floor, there is inconsistency. PW2 says that there are 4 other tenants. PW3 says that about 1 tenant living in the upper floor, 1 Gujarati female. And PW4 also says that there are 4 other tenants.
PW2. PW2 has not been cross-examined.
He has been cross-examined.
When? Where is his cross-examination? Read his cross-examination.
On 24 January 2008, cross-examined Vivadet Parisar.
Just a moment.
Yes.
He has stated that he is living only in one room, his 2 sons, para number 12. यह कि मेरे परिवार में मेरी पत्नी तथा हम लोगों का 2 लड़का है, हम लोगों को रहने के लिए सिर्फ एक ही कमरा है, जो काफी कम है. करेक्ट?
Paragraph 12 of his.
Para 12 of his chief.
The chief is in this copy, it is until paragraph 10 only, and then it comes to an end of PW.
We'll go by our record. No? दिखाई सब error है. चलो 1 PW1 कौन है? अच्छा PW1 कौन है? अजीत कुमार गुप्ता. He is the plaintiff.
One is Pramod Kumar Gupta.
वादी गवाह साक्ष्य नंबर 1
Pramod Kumar Gupta.
अजीत कुमार गुप्ता.
Also, in the findings of the trial court, it has come that PW1 is Pramod Kumar Gupta and plaintiff is PW2.
तो ये क्या है? What is this?
Internal page 5 of the trial court judgment.
I don't get it. साक्ष्य संख्या 1 प्रमोद कुमार गुप्ता भी इसका भी साक्ष्य संख्या 1 लिखा गया है इसमें ऊपर, लेकिन अजीत कुमार गुप्ता इज दिस दोनों का वादी साक्ष्य संख्या 1 लिखा गया है. दोनों हाँ इस पे 2 लिखना था, लेकिन he has been examined as 1. इसके बाद वाला में 2 इसलिए लिखा हुआ है क्योंकि उसका क्रॉस एग्जामिनेशन मुख्य परीक्षा. ये कंटिन्यूटी में है क्या? You have to read this. His chief is in 2 parts
Yes.
and 2 different dates.
Yes.
Para 5 of the first chief,
Paragraph 12.
para 12. Sorry.
Yes.
And in continuity further he has deposed on the next day in 10 more paragraphs, and then there is cross. So he has said that he has 1 room,
And
2 sons, wife, and needs accommodation. So personal necessity is not in dispute, nor any substantial question of law has been framed on that. Whether there was any personal necessity, that is not the substantial question. Like,
And further, PW4 has also stated about the plaintiff's bona fide need in paragraph 8 of his chief examination. PW4 is his brother.
we are not on bona
Yes.
fide also. विवादित परिसर का एक भी कमरा खाली नहीं है. यह स्पेसिफिकली स्टेटेड so in his cross examination.
In addition, one aspect is that although he had stated that he needed it, and he has also said in his deposition, but this aspect had to be considered and by the learned courts below,
That's
and that consideration is absent.
We'll see. और इस पे भी कोई क्रॉस नहीं है that he is living in one room. There is no cross examination on this also. For the learned counsel, on behalf of the appellant, nobody has entered appearance in spite of service of notice
May I also tender one judgment on perversity?
this appeal was admitted for final hearing by order dated 28/11/2024 on the following substantial questions of law. So, while referring to the substantial questions of law and the judgments specifically mentioned, in the said substantial question of law of the Honorable this court, by framing the substantial question of law, has specifically referred to paragraph 14 of the judgment of Shiv Swarup Gupta Sutta and paragraph 60 of the judgment of Murthy Sutta. However, the learned counsel has referred to paragraph 60 and 62 of the judgment of Murthy Sutta. The aforesaid paragraphs of the judgment are quoted as under. The learned counsel for the appellant has submitted that the appellant is the tenant in the premises and the sole plaintiff had filed suit for eviction on the ground of personal necessity and also default in payment of rent. The learned trial court decreed the suit on both the grounds, but so far as the learned first appellate court is concerned, the point of default was reversed and still the direction to evict was sustained on the ground of personal necessity. The Learned Counsel has, by referring to the first substantial question of law, the Learned Counsel has submitted that it was the specific case of the dependent that the plaintiff had alternative vacant accommodation available, but this aspect of the matter has not been properly considered by both the courts, particularly the Learned First Appellate Court. The Learned Counsel has referred to the findings recorded in paragraph 14 of the First Appellate Court's judgment and has submitted that the First Appellate Court straightaway concluded that there is evidence on record to prove that plaintiff needs the sole property for his bona fide and personal requirement. But in order to arrive at this conclusion, there is no discussion of the evidences on record.
That is in paragraph 13 and 14 both.
Paragraph 13 and 14 both. Okay. 13 में तो default है.
Yeah, part of para 13 last.
Okay. By referring to paragraph part of para 13, last part of paragraph 13 and paragraph 14. The Learned Counsel has submitted that the findings recorded by the First Appellate Court is cryptic and perverse, and therefore the second substantial question of law is also required to be answered in favor of the appellant, as the Learned First Appellate Court has not followed the principles of Order 41, Rule 31 of CPC. While referring to the judgment, in the case of Shiv Sarup Gupta, Supra, the Learned Counsel has submitted that the manner in which the availability of alternative accommodation is to be considered has been laid down in the state judgment, but the learned First Appellate Court has not exercised its powers in accordance with it. While holding the finding, while holding that the landlord required the suit property for his bona fide and personal use. The learned counsel has then referred to the judgment passed in the case of Murthy Sutra and has submitted that it is not open to the First Appellate Court to decide the case in a shortcut method, bereft of reasons and the application of mind and the is also required to be reflected even while upholding the findings of the learned tribe. He submits that so far as the point regarding default in payment of rent is concerned, he has no grievance as the First Appellate Court has ultimately recorded finding in favor of the appellant. But so far as bona fide requirement of landlord is concerned, the necessary exercise has not been done in line with paragraph 60 of the judgment passed by the Honorable Supreme Court in the case of Murthy. The learned counsel has also referred to paragraph 62 of the state judgment to submit that as per order 41/31, the judgment of the appellate court shall state the point for determination, the decision thereon, the reasons for decision, and where the decree appealed from it is reversed or varied, the relief to which the appellant is entitled. The learned counsel has submitted that although the point for determination has been framed, but the decision thereon is bereft of reasons, and therefore the mandate of Order 41, Rule 31 of CPC has not been complied. After hearing the learned counsel for the appellant, and upon going through the impugned judgments and the materials placed on record, this court finds that so far as the substantial question of law number 1 is concerned, it is कौन से ऑर्डर से बना था?
28/11.
Yes. It is relating to as to whether the appellate court has committed perversity by not considering the bona fide of the landlord in not occupying alternative accommodation and whether the landlord unreasonably refused to accept the alternative occupation to satisfy his need claimed by him. This court finds that the specific case of the landlord with respect to bona fide requirement was that family members of the plaintiff have enormously increased and all of them have become adult. As such, there is scarcity of accommodation, and as such, the tenanted premises was urgently required to the plaintiff for his personal bona fide requirement and in good faith. It was his further case that for the purpose of fulfillment of personal requirement, he had requested the defendant to give vacant possession of the suit premises as he required the premises in good faith for his own use and occupation. And the defendant realized and appreciated his genuineness and promised and assured that he would vacate the suit premises and hand over the vacant possession to him within 2 months. But in spite of that, the defendant failed to do so. And ultimately on 10/12/2005, the defendant refused to vacate and also did not pay the arrears of rent. However, so far as the default in payment of rent is concerned, the same is not the subject matter of the present second appeal, considering the nature of substantiation of law as framed. So far as the defendant is concerned, they had filed a written statement stating that they not only denied the relationship of landlord and tenant and also denied the allegation of default and specifically stated that the personal requirement of the plaintiff shall not be considered in the present suit, since several portions of the building premises adjacent not to the tenanted premises in occupation of the defendant and 2 more flats of upper floor of the building were vacant at that moment, which had caused disentitlement of any degree of personal necessity of the plaintiff. It was also stated that the defendant had invested huge money in the tenanted premises. For construction of electric wiring, kitchen, etc. And it was stated that the only intention of the plaintiff was that to evict the defendant, and there was no need or requirement of tenanted premises. And the plaintiff and his brothers were regularly quarreling amongst themselves with regard to the suit premises. The trial court framed as many as 9 issues And the issue number 7 was whether the plaintiffs have required the suit premises reasonably and in good faith for their personal use and occupation and personal necessity. The issue of partial eviction was also framed. However, the subject matter of the present case is in connection with issue number 7. Though the point for partial eviction was concurrently held and decided against the defendant by both the courts. The issue number 5, 6, 7 and 8 framed by the learned trial court were taken up together, and the witnesses and other materials on record were duly discussed by the learned trial court. The learned trial court, after considering the materials on record, held that the suit premises was required bona fide for the purposes of the plaintiff, as because his family members had enormously increased and all of them had become adult, and as such there was scarcity of accommodation. There is no specific finding. The learned there is no specific finding in with regard to this availability of alternative space by the trial court.
There is no.
Correct?
Yes.
However, the perusal of the judgment of the learned trial court reveals that no specific finding as such was recorded in connection with availability of alternative accommodation, alternative suitable accommodation for the landlord. So far as the learned first appellate court is concerned, the points for determination have been framed in paragraph 9 of the judgment, which are as follows. The learned first appellate court considered both the points together by paragraph 10 onwards, and the findings start from paragraph 11 of the judgment. The learned first appellate court has extensively referred to the evidence of PW2, the plaintiff himself, and has recorded that he has stated that there was no room vacant in the suit premises. In the upper stairs of the house, late Mohan Lal Chauhan lived with his family. Lives with his family. Late लिख दिया.
It appears that he has passed from his
हाँ,
deposition.
he might have passed. Bakru Lal Solanki also lived there, and presently the plaintiff was residing with his family in another house near DAV school, Katras. Mahesh Chandra Gupta PW3 had supported the case of the plaintiff and further stated that his house was about 200 to 250 yards away from the disputed property, which belonged to Ajit Kumar Gupta, the plaintiff. Ajit Kumar Gupta had 4 brothers and one of his brother had died. And that there has been no partition amongst the family members of Ajit Kumar Gupta. This court further finds that the learned trial court, the learned first appellate court, ultimately held in paragraph 14 that the plaintiff required the suit premises for his bona fide personal requirement. This court finds that the specific case of the defendant, that on the upper floor of the suit premises there were vacant rooms stood specifically negated by the evidence of PW2, as he had stated clearly that there was no room vacant in the suit premises, and the manner in which the upper floors were occupied was also mentioned.
Regarding this leadership, may I state one thing?
This court is of the view that the specific plea of the defendant with regard to availability of vacant rooms in the suit premises was not proved in view of the statements made by PW2 in his evidence, and as discussed by the learned first appellate court in paragraph 11 of the judgment. This court is of the view that paragraph 14 of the judgment cannot be seen in isolation, as the findings of the learned first appellate court begins right from paragraph 10 of the judgment, and the discussion with regard to availability of vacant rooms in the suit premises is reflecting from paragraph 11 of the judgment. While recording the finding, in view of the non-availability of any vacant room in the suit premises, the learned first appellate court has recorded a finding that the plaintiff needed the suit premises for his bona fide and personal requirement. This court has also gone through the evidence of PW2, who has deposed on 2 dates. That is on 25/4/2006 and then on 26/6/2007. On 25/4/2006, he has clearly stated in paragraph 12 that in his family there is his wife and 2 sons, and they have only 1 room for accommodation, which is not enough for them. And in his cross-examination at paragraph 20, he has clearly stated that there is no vacant room in the suit premises. And he has also stated this court finds that the learned first appellate court has considered the materials on record and has found that the plaintiff had stated that there were no vacant rooms in the suit premises, and ultimately recorded a finding of bona fide requirement in favor of the plaintiff. This court is of the considered view that while considering the bona fide requirement of the plaintiff, the learned court has not committed any illegality so far as alternative accommodation is concerned, illegality or perversity so far as availability of alternative requirement is concerned, inasmuch as the learned court specifically recorded that PW2 had stated that there was no vacant rooms in the suit premises, although the defendant had asserted that there were vacant rooms, but there is accordingly the substantial question of law number 1 is decided in favor of the respondents, defendant, in favor of the plaintiff and against the defendant, appellant. So far as the second substantial question of law is concerned, this court finds that the appellant has no grievance so far as decision with regard to other issues are concerned, particularly has no grievance with regard to default in payment of rent, in as much as the first appellate court, after thoroughly considering the materials on record, has found that the defendant was not a defaulter in payment of rent and has upset the judgment passed by the learned trial court. So far as the bona fide requirement of landlord is concerned, the records reveal that the requirement of the landlord is not in dispute. In as much as the fact that the family members of the plaintiff landlord had increased and he needed more accommodation has been duly considered by both the courts. And so far as the plea of alternative accommodation is concerned, the learned trial court has not returned any specific finding on this, but the learned first appellate court, being the final court on fact and law, has clearly considered the evidence of the plaintiff that no room was vacant in the suit premises, and consequently has recorded a finding that the landlord had bona fide requirement and sustained the order of eviction on the point of bona fide requirement of the landlord. This court is of the view that the learned first appellate court has done the needful in terms of Order 41, Rule 31 of CPC, and accordingly the second substantial question of law is also decided against the appellant and in favor of the respondents.
Your Ladyship, may I just make one submission if I may? The second substantial question of law with regard to partial eviction, there is no finding. There is finding that he needed it, he had only one room. But so far as regarding
Partial eviction का substantial question of law कहाँ पर?
बना नहीं है, but second कैबिनेट में सबसे मुझे सबसे second consider नहीं हुआ and partial consider ही नहीं हुआ है. That was statutorily required to be considered.